On public investigation, my lord, I was directed to file an amendment of pleadings.
Huh?
Amendment of pleadings, my lord. Not is given, note date was given. It was adjourned to 2 weeks, my lord.
Huh? It will come up day after.
Let me make a mention. Well, the request for hearing of a intra-court appeal of 2016 filed a petition for fixing a early date for hearing of that petition.
Day after.
Fixed
Day
it
after.
with the petition.
Your Lordship's permission. We have filed a stay vacate petition on 24/12/2021 in relation to the Securitization Act, Millard, and in which unconditional stay was granted on 19/11/2021. I filed a IA 1 of 2023 on 6/10 to fix an early date of hearing.
What vacating stay you want? Hearing on vacating stay. Thursday.
Much.
A matter in the ERT Act, my lord. A bank, against the bank, a stay is obtained against the order of the recovery officer.
You have a vacating stay.
Yes,
petition
vacate stay,
pending?
vacate stay
Yes.
filed and
Thursday.
obliged.
Commercial court appeal, your lordship. I have filed contempt, your lordship. There is a threat of alienation, your lordship. The status quo order in my favor, your lordship. The last occasion, your lordship.
What will happen, supposing
I mean, the threat of alienation, your lordship. Any date may be given. Threat of alienation, your lordship.
day after?
Obliged.
My lords, before my friend begins his arguments, I have a preliminary objection on the maintainability of the writ appeal. It's against an ad interim order passed by the learned single judge, and the writ petition itself is posted to 10. They filed their appearance there. They filed their appearance. They've not filed a counter. They choose to file a writ appeal. The lordships know they both apex court and a division bench of our High Court has said, unless it's a judgment, a writ appeal will apply.
It's his appeal. Let this permit him to open now.
I just wanted to bring this to your lordship because it's a practice, my lord. Normally, if there's an objection to the
No,
maintainability. Yeah, I'll stay.
But he has a right to address the court, or he doesn't have.
Yeah, of course he does.
That-
May it please, my lords. My lord, the appellant before your lordship is the second respondent. Writ petition itself has been filed, my lord, for a mandamus against a bank for invocation of, my lord, a bank guarantee. My lord, the writ petition as a company does business, my lord, in supply and erection and commissioning of, my lord, electrical overhead lines and railway overhead lines.
That's all right.
Yes.
It's an ex parte interim order.
Maybe, yeah.
Matter is fixed for 10/11/23.
True.
You have entered appearance. Please file an application seeking vacation of the order.
But what I respectfully submit is that please see, my lord, it's not maintainable, writ petition itself, for the reason, my lord,
Then raise that question before the learned single judge.
Lord,
It doesn't mean that supposing if somebody files a writ appeal, you will file SLP before Supreme Court and say that writ appeal is not maintainable.
I wouldn't say.
What will Supreme Court do?
No.
Supreme Court will create you to us saying that raise the plea of maintainability there.
My lord, I bow to your lordship's observation. But as far as this is concerned, it is a settled proposition of law, as my lords are aware. Throughout, my lord, and it's a private agreement between parties. My lord, the invocation of a bank guarantee in a writ petition. All these, my lord, are matters that stare in the face. My lord, they led the learned single judge to believe on the basis of a judgment which arose, my lord, in a civil suit. There's an arbitration clause as well. So all these, what I respectfully
Mr.
submit is that
Madam's pencil. It's kept here. I can't even reach. What? Yes.
so your lordships are inclined to, my lord, say that I should go to before the single judge. Very well,
Yes.
sir. I'll do that.
Mark the presence. हाँ हाँ हाँ
Initially, I filed an essay that my opinions are that bank have not completed ordering class seven of security interest. As well as the bank, fixed deposit reserve price was lower than the market value. It was lower than the market value, actually.
हाँ
So the same, the essay was dismissed. So I preferred an appeal, approached the appellant tribunal. There I was directed to deposit 50%
हाँ
of the total due amount,
हाँ
which would be nearly 5 crores, Lordship.
Whatever.
Approximately 5%. Total due amount according to the bank is 10 crores. In that I have to deposit in 50%. 50%. So I have filed a writ application challenging the same. Pending the same, this my the appeal was dismissed, Lordship.
What is the law? There is a judgment of Supreme Court with regard to pre-deposit. Have you
Yes, sir.
examined it?
I'm not asking for the release of the property. I'm asking only my grievance is that they have not, there is a violation as well as the mark, the amount which was quoted is comparatively less to the card value, government card value.
This order is 13th April 23 is an order passed by the Debt Recovery Appellate Tribunal, correct?
Yes, yes, Lord.
Huh.
Yes.
Then
I have preferred
so
an
you-
appeal. I filed an
you have-
application.
you have not complied with the conditions.
I'm not
noted.
complied, Lordship. I've filed an WP challenging the same. It was-
Filed a deputy, what?
The writ petition I filed, Lordship, challenging the order given
What? There is a judgment of the Supreme Court, like dealing with pre-deposit.
because, Lordship, already my this thing.
We are asking you about legal position. You are saying amount is 5 crore, my condition is not good.
Yes, my
It's not the legal position, law declared by Supreme Court that your condition is not
I
good.
filed a writ application challenging the same, but I've filed a memo saying that the writ
No, what is wrong?
pending
I
will
mean,
then.
there is no power to order this thing pre-deposit surface act, madam. There is a judgment of the Supreme Court, Mr.
Yes, Lordship, there is a judgment
You
in
want-
that if I am
this
claiming
expect
the
us
right
to
of
do
the
the-
property, then I have to deposit the 50% of. Here I'm not claiming the right. I'm saying that the.
Where is that judgment? Who says that this thing?
This judgment
Ah.
passed.
See,
Narayan
second
Sen-
proviso.
Yes, Lord.
What is wrong, Mr.? Second proviso to section 18. Do you have the book?
I don't have.
Do you have the book Surface Act?
Presently, I'm not carrying it, Lordship.
Huh?
I apologize.
And there's no question of apology, Mr. It's not our case.
No, no,
You
I-
will,
no,
all right,
no.
yes, in this, anything else?
Nothing, Lordship. I have
Nothing,
filed an
no?
appeal.
Ah,
I made an requisition. I filed a memo stating that there is a writ petition, but it was not considered. And that too, time was granted for me for the deposit amount was till 30 June. And it was dismissed. The bench have come up before the Hyderabad on 26th, and the same date was dismissed. I asked because the matter was listed on 2nd of July. It was not considered, Lord.
See, debts recovery tribunal order you are challenging,
Yes, Lord.
not even an appellate tribunal, right? So
Yes.
you have remedy under section 18. What, Mr.? You are challenging an order passed by the debt recovery tribunal.
Yes, yes, yes.
You have the remedy of an appeal. In this petition under in this writ petition, comma, the petition.
Published.
Yes. Yes.
Your Lordship, this current present writ petition filed under the Article 226 of the Constitution.
Uh-huh.
So for the non-considering the representations by the petitioner
Huh.
as a PIL by the respondent number 128
Hmm.
against the respondent number 9278, my lord.
Who will decide the representation?
Honorable
You
Court.
look into it, Mister. What is it? Huh? Heard on the.
May please. Not a legal construction by the respondent number 9, my lord. We made several representation and the FIR also registered. Complaint given by the executive engineer of the R&B, my lord. In spite of that, they are not taking any action, completely in occupation of pond, my lord. That is Komatkunta Cheru, where total reservoir is occupied and block 8-9 is illegally constructed. And commissioner, page 67, my lord, page 67 completely given report also by the commissioner to demolish the same.
My lord, in this matter, we have already taken action, my lord. And HMDA also, my lord, issued, kept their permission in abeyance. That order was challenged by the my lord, unofficial respondent before the honorable court. My lord, that repetition number is,
So there is a stay, so you can't do anything, right?
no, my lord. Here in this honorable court, my lord, out of
What
12
action have you taken?
my lord, conducted,
Nothing, no action.
direction was given to my lord, to conduct resurvey. My lord, resurvey is in progress. My lord, kindly give us some time, my lord. We'll conduct resurvey and we'll file counter in this matter, my lord.
Learn it. Yes.
Achha, please.
I beg to appear, my lord.
Apple, last time I was not present.
Huh?
My apologies, last Monday I was not present. This presence here.
Who appears? Yes, Mr.
I am correspondent.
What ready?
Yes.
Yes.
Small CR.
CM is that's already 10th March 2023 minute.
Huh?
Made by my permission seeking to file a rejoinder. So the counter file is not allowed.
Hmm.
Having allowed their application to citizen subsequent pleadings. But the issue is minute the decree has been passed by Madras High Court, an expert decree for theory of law.
What is the objection? Now, he let him file a rejoinder. If according to you, then we will have to say that the no adverse inference shall be drawn against him in respect of any of the averments made in the rejoinder. We will have to either observe this or let him file. There is nothing to contest, Mr.
But I
Sami.
may be
Strictly speaking.
I may be permitted to file any further pleadings if it is required.
Huh?
If it is required, I may be permitted to file any further,
What? You have filed a rejoinder already, right?
I file.
Then after sub rejoinder, what else?
Kindly see for a minute.
No, if law permits you to file any additional pleadings, we don't know.
Kindly give me the liberty.
This,
Kindly give me the
No,
liberty
this-
and let it pass.
all right.
I have no objection.
Liberty means you are at liberty to take recourse to, I mean, we don't know whether law permits or not.
But kindly, only 1 minute, may I say. But the EP has been, a 2000 minute, a decree of recovery of amount of 5 crores has been filed. The 2006 decree has become final.
So we can say that the proceeding shall be concluded expeditiously. That we can say.
It's always,
There's no point in keeping this petition pending here.
yes,
All right.
yes. I'm obliged.
This sort of decided for the record, original record.
Yes.
Dispute for the ownership certificate is issued or not.
Ah.
And on the last application, then the government will furnish the record.
Ah.
It comprises of three components.
Ah.
It is under PT Act, the extract of original register, PT register, that is of 1950. That is filed from page 1 to 5.
No, but some in substance, they say that there is no record.
Yes. But my objection is,
Survey number not there.
my objection is the pages 1 to 5 are the extracts of the
No,
original.
but have you filed any objection to this?
No, Miller, they have not filed in Telugu. Only the original copy of the record is not given to us. But it is some private translator has translated the record, and only the translated paper is given to us. And the second list is only.
Go through here the record with you, original record if you
And
can.
the second regard is provisional list prepared of the persons who are eligible to be given 38 certificate prepared under Rule 4.1 is given. And admittedly, the final list of protected tenants who are eligible for protected tenancy certificate, ownership certificate is not furnished in the record, entire record. So
It is not in the, if it is not in the provisional one, there is no question of being in the final one.
But you give him a copy of the original record also, why to keep
This is
it?
the very torn condition, they can verify it, they can't be.
You verify, Mr. Go through and you can address us tomorrow day after if you want.
But two more matters are also arising from the same judgment, Manoj.
Yes.
In our matter, we find an IA3 of 2023, Manoj, before your lordships. But after the record has been produced, bringing to the fact, Manoj, saying that 4.1 has been, register has been filed, not the 4.3. The land government leader said if their name is not there in 4.1, it will not be there in 4.3. Manoj, inviting the objections itself is, Manoj, to, if somebody is left over, but he can be included, Manoj. That argument of my friend, Manoj, may not be right. In addition to that, Manoj, because having looked into the record which has been produced, but 3080 certificates, some certificates which have been produced show Manoj LRE number. It is land reforms proceedings. But there was a practice, Manoj, because the authority was the same, Manoj, for granting 3080 certificate and considering land reforms tribunal here. But they followed the procedure whenever the landlord has declared the entire land, Manoj, the land which is liable to be excluded because it is 3080 certificates are issued. Proceedings were issued, Manoj, saying LRE.
What is your idea?
We have asked for that IA3, man. We have asked for that record also, land reforms record of the original owner. But your lordship must see the prayer.
That regard, most important, because the PT certificates are issued by the RDO while sitting not as a tenancy tribunal under Tenancy Act. But whenever declarations are filed by the original landowners, if they own 100 acres, they may not be in possession of entire acres. So if PTs are entitled, Miller, the same RDO who is all.
Mr. You may respond to their IA what?
I'm opposing their IA, Malad. I'm opposing their IA because they're making a roving inquiry in the writ appeal. Malad, they should have obtained all the material and then filed the writ appeals. In the writ petition before learned single judge, Malad, they did not place on the record at all. In the writ appeal,
respond to their IA whatever.
yes, I'll file a counter, Malad, for the
How much time?
a week, Malad.
Weeks, right? Next week?
Yes.
Which date? Any? You tell us.
Any day convenient, please.
15th November?
Yes.
15th November?
Meanwhile, Miller, your last permit us.
Yes. We have volunteered.
May I request your lordships to 17th November, Manoj, if it is not inconvenient for your lordships.
Yes, please. 17. All right. Learned.
7. My lord, my friend had requested for 17.
17, sorry, 17.
Please. But I paid for the friend. Last time my friend said, your lordship,
This is connected, no?
not connected, my lord. Your lordship had directed that to explore a possibility of a settlement address.
Huh?
My lord, matter came on 17th October.
Ah, yes. What happened?
I'm told, my lords, they came for a discussion at one point in time and then withdrew and there was no further discussion.
I don't know.
And now the corporation would like to see that the matter is heard on merits. That's my instruction.
I'll just check with the briefing council. Your lordship may have it next week. Meanwhile, I'll get back. Otherwise, we'll proceed.
Next week? Learned senior counsel for the
Obliged.
The matter where there's a challenge to an order passed by the DRT not granted to pay in respect of 3 crore 14 lakh loan, where I am willing to pay the entire money now. The two other petitions
your property has been sold probably.
has been sold. And after I filed the writ petition, they registered the sale certificate. And now they file a counter saying that we have registered the sale certificate after the writ is made, basically to make it instruction. But my respectful submission is this.
No, but in any case, when a sale, even if sale was conducted and even assuming that some right was inchoate right was this thing created in favor of the auction purchaser, he would not have left it. It's out of now handling. Bank cannot settle the matter now.
Yes, sir.
Having you will.
But the DRT, there is an
There is alternative remedy, Mr.
I'll just answer one thing. As DRT has said, the sale will be subject to the result of the essay. But I'm only saying, let the essay be decided within 6 months. Let the purchaser not create third-party rights. I filed an implete and an application not to create alienate third-party rights. Bank cannot have any objection.
As far as
And essay can be decided.
as far as disposal at the earliest, I have no objection at all. And insofar as
Mr. You can file an application before. Why seek an injunction in the writ petition? You can file this thing, application in the DRT, restraining the purchaser when it has been done.
The 30th October, they registered.
Oh, no, when this thing, like not the presence with consent of the parties.
There are 5.
about the registration, only one aspect I would like to submit.
5 registered.
It only just to place an.
Yes. You just now you said that I have no, nobody can, even if you have objection, we can direct the DRT to decide in 6 months.
I have no objection for it.
No, even if you have objection, we can direct.
Settling that.
So then what is sale deed? We know that you are interested in selling the property and again purchasing it back from him. That's all you do.
What I wanted to bring to your lordship notice is, we have issued the sale certificate on 18th October 2023.
We are not doing anything with the, we understand your thing, Mr. You are real estate agents, right? You take a guarantee that we will, this thing pass on flawless title and we will handle the litigation on your behalf also, don't worry. That's all what you do. That's why people don't turn up for taking loans from you. This is what you do. It has been done. We are only, Mr. We are only issuing a direction to the DRT. We are not even granting a stay which is being prayed for by. You make an application.
Yes, may I give the list of the SS and OS pending? Because I have counter claims because they have not complied with some amount.
No, but this OA out of which this arises, we will say that it will be decided.
That arises out of SA 348,
SA 348.
and the OS.
Where is the prayer clause? Which page?
But in the essay, my lord,
Not essay, Mr. Rate petition.
yes, the petition prayer, my lord, is to set aside the order dated 26th October. That is at
26th.
page number 12, my lord.
What is 26th October?
On the 3rd October, the stay of action was not granted.
Ah.
And 26th October, my lord, not to create rights in respect, taking over of the possession. Under
What
section
happened?
14.
Both rejected.
Both rejected. So on the ground that
In this
my lord,
rate
it will be
petition.
subject to the essay.
All right.
Essay it is
In the
subject
rate
to the-
petition.
But there are four connected matters, my lord, with the petitioners. Third and fourth petitioners have a counter claim. But if those can also be directed to be disposed of. Some of them pleadings are also complete. But what had happened is,
Here.
we had built a plant in Germany.
Huh?
I have no difficulty in that, yes.
No, these are the
Also, all right.
these are the numbers.
OA number so and so, right?
Yes.
Is submission also you include? OA, why are you looking there? Nobody there.
But they are in a different category, different, not, this is in tier one, and they are tier,
They're all together.
OS, OS.
But they may, it's 6 months direction, irrespective of where it is, because they are petitioners 3 and 4 in the writ petition.
No, if they are pending before, then it seems, Mr. It arises, it has a limited scope.
Yes.
Why do you find, you can file a separate
file a
petition,
separate
CP. Or don't, yes.
Obliges.
This matter I was directed to conduct survey,
Huh?
Just, this matter was the last occasion I was directed to conduct survey on the subject land. Survey has been conducted. I'll file my report through and a short date, but I just received the report. We'll go ahead. Next week.
Learned GP for revenue under, GP for revenue.
may be taken up because another connected matter is there, which has to be developed with this case.
Yes, we have issued a direction to, you did not get it right. Tell him what is the order passed, he doesn't know probably. No, you must explain to him what has happened. He has not understood what has happened. Tell him, Mr.
Obliged.
Lordships made, please your lordships. 14 to 22.
Counter filed.
In some of the matters, counters fight, but the lead matter itself is not listed before your lordships.
Which is that matter?
WP 25036 of 2016.
WP
25036 of 2016.
250
36
of
2016.
government. In that case, you have filed counter.
Yes.
We'll take it up along with that.
Yes, your lordship.
When?
Any day.
There is
Any
another
day.
writ appeal billet. There is another writ appeal billet.
Sorry, what?
677 by 16.
Hey, all these,
lordship.
what we saw in these petitions was your counter was not there in first few matters. So therefore we thought that it has to be adjourned.
Your lordships,
We'll see.
if I may make a submission, your lordships, these cases are part of a Supreme Court remand matter, your lordships, which your lordships have passed orders.
Huh?
Your lordships have passed orders on 4th September, your lordships. In fact, these matters also were supposed to be heard with it, but for reasons best known, they were untagged, your lordships. But however, all these writ petitions are mentioned in your lordship's order also on page 3. Your lordship's orders.
See, Mr. You give him a copy, madam.
Yes. In fact, pursuant to a memo filed in this court itself, the Honorable Division Bench in 2020 had passed final orders, which were taken to the Supreme Court by the government. And half of those matters, and the entire matter was remanded, and half of those matters.
This is an order based on consent. This order, there is no adjudication.
Yes, your lordships. Yes, your lordships.
They have to agree what.
It's part of the same.
No, I'll go through this order billet because.
You go through it now. What is it? We are also going through it. You go through it.
If this order is passed, billet, I have no objection. If my friend is billet willing. Up to direction 1, 2 and 3 billet are relevant billet only for the purpose of these cases. Fourth direction billet is specific to billet that case.
Yes.
Yes, madam.
Yes, your lordships. In fact, the very writ petitions are for R&R entitlements, which your lordships have.
Directions
1 to 3.
1 to 3 may be granted.
Yes.
All the cases.
All the cases.
In fact, your lordships, item number 15 may not be a part of this batch, your lordships. Somehow it got entangled into this. Item number 15 is not a part of this, your lordships. 14, 16,
Item 15 and 20 minute are not connected.
15 and 20.
20 are not connected.
So item 15 and 20, write the order. Let these items.
But they were paid the compensation. I have also filed a memo.
that I'm not sure about those.
Item 16.
Ah,
They were paid the amounts on 27/3/2021.
27/3/21.
Yes.
Yes, with
Item 16.
infractions.
Hmm. 2, 3.
One, the
One,
Roman
two,
numeral
three.
1 to
Ah.
13, your lordships.
Yes.
Yes, obliged, your lordships, deeply obliged.
Font.
23.
Yes, sir. On 14th February, Your Lordship, this matter was directed to be posted for hearing. The matter was admitted, Your Lordship, on 14th
Huh?
February. This matter was admitted on 14th February 2023 and posted.
14 February.
Yes, Your Lordship, by an earlier page. It was directed to be posted for hearing.
This is
Leading
which item, madam? This is which item?
This is the case, Miller, where the petition was removed without conducting any inquiry.
Huh?
The inquiry has been dispensed with. And now that the petitioner is.
Hey, but how this is for interlocutory? It has to come up for hearing. How it can come up under the caption interlocutory?
Madam, the petitioner might have submitted before Your Lordship for a request for the posting, Miller.
Huh?
The petitioner might have
No, there
submitted
is
Your Lordship for posting of the case. Petitioner is also an advocate now, Miller. They might
no,
have-
no, whatever he is a litigant.
Whatever it is, Miller. My responsibility, Your Lordship, is the inquiry has to be conducted in this case. The inquiry has been dispensed with.
No, it is to be listed for final hearing, right? Hearing. How it can't come up interlocutory?
Your Lordship is
In view of order dated 14 to six years should be heard. What, I mean, well, 97, 98, 2006 appeal should not be heard because they are 55 years.
What is my
Only 2023 matter because he is 66.
What is my
It's not the criteria.
I'll accept, Miller. What is my contention, Miller? The end of the day, if Your Lordship remained back for conducting the inquiry, by the time you may be there, you may not
It
be.
will, no,
But finally,
how can you argue like this? How can you be so pessimistic about things to come? We don't know, like the longevity age was gone up. You are saying that 66, if I tell any senior advocate who is above 66 to be an old man, he will feel offended. He will say that how are you describing me as an old man? And
Seniority wise, Miller, it may take 5 years, Miller, at least. That's what my.
you can make a mention, Mr. any day. But this can't be done like this. We will not play to the tricks of the registry that it is listed for hearing and it comes up for final hearing under a caption IA.
Requesting Your Lordship to
No,
take, Miller.
it depends on you, Mr. The matter is listed. You can make after the motion hearing is over any time at 2:30 or whenever you can make a mention. I have a case at this number. It may be taken up. We will take it up.
Again, it will be wastage of time. Go I have leave it to you.
Wastage of time.
Again, I have to take time of Your Lordship for convincing this case what is happened, why, what is the urgency.
No, this is it will be included in the final hearing list. We are not adjourning it. We are not saying, we have said, no, let this case be included.
That I have no other.
No, for that, Mr. We are sure that you must not have prepared a synopsis. There are ways and ways to assess the court, right? That you will not do. Entire burden will be what land, where, which village, what is the extent, what survey number, everything we have to write. That you will not do. And only say that he is an advocate. So the law doesn't say that case of an advocate deserves precedence over everything else.
Because he might have mentioned that's what it's.
Nothing. We don't know. Yes.
I can take it work. Take about it.
Call Rahul. (24) Restoration petition. Or it was dismissed. Nobody's appeal. Huh?
We have no objection. We have discussed the item.
Heard on IA about
Much of that.
May please, Lordship.
what early date?
Well, I'm only seeking expedite hearing, my lord, in article.
We'll consider your application in January, Mr.
Kindly see the docket proceedings dated 11/7/2023, 11/7/2023, man.
11/7. So what is it? I mean, there's no suspense about it. You tell, no? You know it.
In fact, there is no suspense. I'm only trying to canvass is that, my lord. Already, my lord, the record is produced before Lordship and pleadings are completed. This has to only heard, my lord.
Everything is to be heard only, right?
Yes.
But the only question is who will write judgment? Huh? That's the only thing. Only thing has to be heard. Everything. We don't have this thing. So we'll consider in January. We don't want to reject it. But presently we are dealing with old matters. Let's let
This matter, they are also challenging foreign judice, section 6 of the Criminal Act. The batch of which tomorrow maybe tomorrow they are. So regarding what.
speak into the mic, right? What?
They have challenged one of the ground they have taken regarding foreign judice of the KMLA Adjudication Authority. There are a batch of.
It's not on mic.
He is trying to say that, my lord, there are a batch of cases which are listed before Lordship. Tomorrow, some cases are there with regard to the ED matters, my lord, wherein, my lord, the maintainability of PMLA cases have been challenged in those cases. My lord, those cases are coming up for
Maintainability of PMLA cases?
with regard to the seizure of the properties. My lord.
Maintainability of the proceeding under PMLA?
Yes, my lord. Yes, my lord.
Achha.
Yes,
Proceeding under PMLA Act is under challenge.
Challenges.
So
he is saying that, my lord, those some cases are coming up for tomorrow. That's what he wants to say.
Millard, that is not my submission. Madam Millard, in the restriction he has taken one of the ground is quorum judice with regard to adjudication authority. Regarding that point, tomorrow there are certain matters which are listed, batch of matters. So the point which is they have raised, one of this point is also covered under those batch matter. Tomorrow they are coming up along with the batch of matters, Millard. That is what my submission. So they have taken one of the plea that.
other pleas are there. No? He wants final hearing of his case. Will yes.
Much.
This case, your lordship, is the petitioner's property, which is a running function hall, was illegally taken possession.
So we had passed some order.
I've got the instructions saying that the property is in survey number 155. The property mortgage is MNR function hall. There is only one function hall that has been identified by the bank. But showing it to be in 159, they have
File
mortgage.
the report, whatever.
Yes, but I've got the
File.
report. I'll file it.
We'll take it up. We go through the report. We will hear it day after tomorrow.
File it.
I take notice for Canara Bank, respond number 4.
After everything is done, you appeal.
No, no, I've been,
You should notice means don't take. Who is asking you to take notice? You have been served, not served.
my father's name has been printed, my lord.
Huh.
I'll file my wakalat.
Huh, you file. May file wakalat and may file counter if so advised. You are not saying I will file counter. What can we do, mister?
My lord, I'll file my counter.
You should say, right? This also should come from the court. No, you file and one day you file wakalat thereafter. Please file. Don't file. It is your case, not ours. You are not saying that I will file.
I'll file my counter.
Say so.
Yes, I'll file my.
So and so accept notice on behalf of the bank. He may also file.
Much obliged.
$27.
I appear in item 31.
Further hearing, what is further hearing?
Comes to hear the matter. So matter arising in Urban Land Ceiling Act, not where the urban lands
Urban land city.
and the possession was taken by the state not as early as in 1999. The learned single judge was pleased to allow the writ petition and also canvassed before my lord's lord, saying that the single judge has gone beyond the scope in the writ petition. But lordship, they're pleased to hear me and the respondent counsel. It's coming off of the respondent's argument.
Yes.
I appear in item 30. I am the society consisting of 67 members who purchased the lands from the original owner under sale rates and other things.
Lordship,
Yes.
also is appearing online.
Yes.
So this is
Item 30.
Lords in which
Yes.
I was supposed to reply today, my lords. I'm extremely sorry that I'm not.
No. You are there. You can argue. Yes.
Yes, my lords. I'm so grateful indeed, my lords. I think if there's one more appeal somebody would like to argue, otherwise I can begin, my lords.
Anybody else, mister? Or we have to hear them only. You are, sir.
I am for item 30 in this case. I filed this appeal because we have purchased these lands from the original owner at the registered sale deeds and everything was completed. We have taken house numbers, we have constructed houses. We have also paid the amounts in the case it's land to the government. Under GO 455 scheme awarded by the government. Those who are in occupation of the lands, if it's going to government, we are to be given regularization of those sites. So saying all these things in a brief. I will submit this about our position.
We have taken notes. No matter. Very. Yes.
It is about 7 acres of land that we are in occupation. We have constructed houses. We are paying taxes. We are on. We got the possession of sale deeds. Registered sale deeds. The statement and other things were also I filed along with my appeal. The page numbers and other things, the lordship. So, pleases I will explain those things for a moment.
Yes. Item number 30 you are appearing.
I am for responded 4 in the petition.
Which case? 30.
Yes, 30.
30.
brief note.
You are appearing for respond number?
4 in the written petition.
Yeah.
It is the association of residents association. And below the brief note that I have submitted, that would indicate our position of these lands right from the year 1991. We have taken these lands under initially under GPA.
Where? How it can be, madam? We had heard them at length. I don't this thing here cases without notes. See that 1 minute. In that pad. These pads you see. Yes.
Let's Lordship, I kindly see for a moment without taking much of your Lordship's time. I have submitted a brief note. Two of my notes.
Brief note.
Yes. Background facts in brief. Page 2, it starts. How we came by, how we have come to possession of these lands. Kindly peruse that. It's a registered association. And we have taken this land, 7 acres of land.
Yes, yes.
The chronology of events, page numbers on page 4. A synopsis chronological letters, I find that certificate of our registration, the list of appellants, the registration numbers, and the house numbers that we have been given, and the application that we have filed for regulation of these lands in the case if it is now going to the government under years. That is to say that we have been there since beginning. In the land and its possession, we have constructed houses, we are staying there. But these points were only to see that our rights are protected. If something is happening in between these parties, only to see that we are also there, we have purchased this under registered sale deeds and all, but that is not our endeavor in this case. Otherwise, now the dispute is between only the government and the owners. I understand it's under ULC. Only to say that 7 acres of piece of land was given to us by the owners under registered sale deeds. We have subsequently also filed.
No, you will get title provided owners get title.
Yes, but otherwise also the other thing is the scheme evolved by the government under 455 GO. Those who are in possession of government lands, their position can be regularized. That we have paid the fees. We have filed all our papers, not a statement. I have also filed a statement. Well, that's all my plea in this case is. Minute 134 to 140. A list of members, registered sale deeds and other things that I have filed. Well, that's all my position in this case is that if you apply, my individual is taken care that we are in possession. Nice.
To represent Team Madan Mohan Rao in item 27. Item 27. In this also similar to my land friend, my applications are page 53 and 59 to the government. We purchased the property in the year 1995 from the original owners.
Is WA? What is the number?
Well, it is WP Millard when we filed the writ petition. Since the matters are similar, all the matters are similar. For that reason, the writ petition is tagged along with this writ appeal. That is my.
That's it. Anything else? Anybody else?
I am appearing in item number 31 minutes. I am permitted to pass on the
31.
31. Writ appeal number 979.
Mr. Prasad, you had given us a synopsis, right? Huh?
I had given.
What? Where is it, madam? He has given a synopsis. He has asked. We have heard these cases. What? Like, in this also, this thing.
Took very extensive notes, as a matter of fact, Millers.
Yes.
Very extensive. notes.
Yes, what do you say? What? Yes.
So far as the present writ appeal 979 is concerned, Millard, the writ petitioner number 19 is the appellant before lordships. Millard, in fact, there is no contest among the petitioners and the respondent number 19 society. Millard, the respondent number 19 society, which is the appellant before lordships, has purchased the property, Millard, from the writ petitioners, and
How it can be, madam? You know, in every case it's there. How it can be? Either you're not seeing properly. He has given a written synopsis. What to do? 17th October. The detailed notes have been taken, madam. You know every case. The file must have been sent for digitization. The records are digitized. No, what is this panel? Where from it can? It has, the records must have been set.
Five zero eight of 2011. The
Get
batch.
508.
OA 508.
Is there notes are there?
Lord, may I make one submission to that?
Ah.
I mean, leave the other put that I will submitted my submission.
Fine. Yes. You said, Mr. Argue whatever, why are you standing?
Perhaps, sir. Let's, the respond number 19 in the writ petition is the appellant before lordships. There is no contest between the writ petitioners and respond number 19. But for the respond number 19 society got included in the land ceiling appeal.
Where are your submissions, Mr. Prasad? Please give a copy.
One copy, my lord, I have passed.
It's read like this. This is the,
That is gist of the matter, my lord. I just passed on to my lord.
where is the synopsis? 979.
Yes, the 979, my lord. I have passed.
You
on.
have given.
Yes.
Where is your synopsis, Mr.?
I just passed on one copy of the gist, the details of the matter. I just had prepared.
Huh?
W is 508.
Yes, 508. 508.
Where is it?
It is titled as just in respect of CC number so and so.
May I just pass on my details?
Where have you given? They have neither the notes nor the synopsis which you have given. To whom have you given? They don't have a copy. See,
It's not inconvenient. I'll make available one more copy.
no, you have to see. We don't remember anything at this point of time, but we have to proceed further. What can be done? It's our problem. Yes.
I can assist.
See this. Yes, Mr. We'll go ahead. Whatever. it is.
So last item 29, the heard by last occasion senior Sudesh Reddy. I saw the synopsis last morning. Item 29, last 5, writ appeal number 657 of 2011. I have given the dates and events last. I have briefed last notice last. I have briefed last notice last. We have given the synopsis and dates and events last.
Synopsis. So you want to argue.
Already argued last time.
So then argued, then why should you stand up then?
Already
You
asked.
heard you, right?
Yes.
You have given this. This is a brief note for my lords.
No, where is your synopsis, Mr.? You did not give it to us. They don't have this. See, the problem is this record was sent for digitization. In the process, whatever has happened, whatever. We'll deal with it. You go ahead, yes.
Yes.
I have a list, Lords.
Ah.
I have a list of dates, my lords, with me, not too long.
Ah.
My lords, if your lordship so pleases, my lord, your lordships can refresh the memory, I'm sure. And we go through the facts, my lords, the things will reappear in your memory, my lord.
Yes.
So, may I request, my lords, Mr. Venugopal to pass on, or Mr. Srinivas Reddy.
Let him complete. He wants to say something.
Yes.
You are saying no dispute, then what? Why are you standing up?
Yeah, no, that's my time is.
No dispute, appellant and this thing. So you are sailing with the appellant. If he succeeds, you will succeed.
No.
If he loses, you will lose.
The subject matter of the writ petition is entirely distinct and different from the lands claimed by the respondent number 19 society. And
Find out. This is not done. Utterly casual approach. Yes.
well, it's during the course of hearing of the writ petition itself,
Like that was very much made clear before the learned single judge to that effect, but the petitioners are not claiming any relief against so far as with the respect number 19 society is concerned. Learned single judge, while delivering the judgment, with great respect, but was omitted. And that is the reason why we had preferred a review application before the learned single judge. And while also we are preferring the review application, we have also filed a joint memo to that effect to state that there is no claim insofar as respect number 19 is concerned. I invite your lordship's kind attention number 175.
You are trying a petition.
I am from the respect number 19.
No, then what?
The writ petitioners are not claiming because these.
So that's all right. We are not saying that they are claiming against you. You are trying to convince us that they have no. If they don't have a claim, they don't have.
We are
not deciding anything.
I am just requesting
validity of urban land proceeding, the position taken or not, notice given or not.
Yes.
That's it.
My only respectful submission is 175. We have filed a joint memo. Page number 175 may be taken. This joint memo can be taken on record.
And petition appeal can be allowed.
It can be disposed of. I am only requesting because they are different from the disputed lands. We have already.
We will have to hear him, right? Joint memo means the state has also signed joint memo.
No.
That
the question itself is not concerning the lands claimed by the respondent.
508.
979. Paper 979. Just now I have passed on the brief note also.
970. 31.
Yes, item number 31.
So what you want, who is the appellant in this case?
The respondent number 19 in the petition is the appellant.
So you want to withdraw this appeal in view of compromise?
This may be taken on record and it can be disposed of accordingly.
This
yes.
One, which page?
175. 175.
170.
Lordship's permission, I may be permitted to read Miller.
1 minute. Joint memo.
Yes.
Yes. Who appears from the respondent in this? Petitioner and respondents. There is a joint memo filed.
So far as this Millard beg to appear, sir, here. This joint memo is concerned, so far as Millard, his apprehension and contention is that his lands were also tied to the ULC matter. Millard, admittedly, there is no dispute that with regard to that. He is unnecessarily filed the appeal. No need of filing an appeal. As apprehension, Millard, he filed the appeal. Now the subject matter is entirely different so far as the proceedings are concerned. Let the is only fine. You want to withdraw and record the faculty withdraw the appeal. That is the only the
Lordship will take into consideration the joint memo and dispose of the. That's
it. Take into the what?
The joint memo filed before the learned.
No, there are there are how many parties? It is filed by respondent number 19 and 1 and 2. Respondent 1 and 2. How this thing? You are.
The review petitioner, respondent number 19 is in the writ petition, and respondent number 1 and 2 are the writ petitioners.
You want to withdraw the petition, we will say so that the matter has been amicably settled. He doesn't want to press. We will dispose it off.
Well, my only concern is this joint memo to be taken. The petitioners are not claiming any relief against the respondent number 19 society. That
petitioners have to say. Yes, Mr. Srivastava, what is it correct?
I think Millers.
Yeah.
So Millers, I beg to appear for the respondents.
No. This item, this WA 979, he says that you don't have a claim and you have entered into a joint settlement with them, whatever joint memo has been filed.
I have not been instructed, my lord, so far as this aspect is concerned, because I am appearing in the lead matter. Nevertheless, my lords, your lordship may, after at some later point of time, may take it up. I'll respond to this. I'll take instructions and respond to this. The joint memo I was with. Apparently, I see, my lord, there is some joint memo, but then let me take instructions, my lords. I have not been brief the matter. So, my lords, let's now start the matter. My lords, the 508, which is the state's appeal, if I may say, my lord, that's the
508.
508, my lord, is a lead matter. And it's my respectful submission, my lord, is that if this appeal is decided, it will take care of, my lords, the rest of the matters, my lords, in natural course. And this is the appeal which our learned friend, Lord Mr. Prasad, argued.
It's surprising that the notes have gone. No?
Lordship's notes, my lords.
First we kept separately there. It was gone for digitization of the receipt sent. Give madam at least a notebook pad. That also you don't have. They have misplaced, obviously. She doesn't know.
Say,
Yes, yes, please go ahead.
this will cause great inconvenience, my lords, to lordships.
Yes, yes, please.
So, my lords, 508, if your lordships will see the array of parties at page 1, 508, my lords, can we have page 1? Because certain things need to be clarified, my lord, because there is, according to me, a lot of mix-up in this matter.
Which one?
Page 1 of the, my lords, the appeal 508 paper book.
508.
Yes. That's it.
WA 508, Mr. You also don't understand like them. Yes.
So, your lordships will notice couple of things, my lords, from the first page itself, and that will provide some clarity. This appeal arises out of, my lord, WP 7762 of 2007. That's the petition which has been decided. Then your lordships will see 1, 2, 3, my lord. That is the Chief Commissioner of Land Administration, Commissioner of Appeals under the ULC Act. That is the appellant number 1. He was respondent number 1 in the writ petition, my lords. Then the second is a special officer and competent authority under the ULC, my lord. He was respondent number 2. And the third is Government of Andhra Pradesh, my lord, respondent number 3 in the writ petition. Now, 1 and 2, my lords, are the landholders whom I represent, my lords. Petition, respondent number 1, who was petition 1, Manubhai Patel, Manubhai Shankarabhai Patel. He is one, my lords, landowner in respect of certain parcels of land. And the second is Natubhai Shankarabhai Patel, my lord. He is the second petitioner in the writ petition and the respondent number 2. Now, from 3 onwards, my lords, going up to 19 or 20, lordships will find there are various, my lord, private parties. And those parties are also, my lord, is taking claim over the land, my lords. Seems to, my lords, according to them, has wasted, my lords, under the provisions of the Act in the state. And they have various bases, my lord, for claiming their interest in the land on the basis of mainly agreement for sale from the landholders. Now they have, my lords, they say that they have acquired interest in the land and their application for regularization, my lord, of their possession is pending before the state government. In some substance, my lord, that's their case. 3 to 20, my lords, of the various learned counsel who have appeared, they have consistently mentioned that their application for regularization of their occupation on the land, my lord, is pending before the state government. But we as the landowners, my lord, have not executed any sale deed, my lords. I will come to that part later. Now, as far as WP 7762 is concerned, my lords, it is strictly arises out of the sealing proceedings. Certain orders which were passed in the sealing proceedings. We have therefore, my lord, to remain confined to the sealing proceedings and the writ petition 7762. And when it is a matter pertaining to the sealing proceedings, my lords, I need not emphasize that the parties who are relevant, my lords, are number one, on one hand, the landholders, my lords, whose lands were declared as surplus. And secondly, my lord, on the other hand, my lord, the competent authority under the Land Sealing Act, the appellate authority, my lord, and the state government, my lords. These are the three concerned parties, my lord. In the sealing proceedings, my lord, the private parties who may have been, my lords, lodging claim in respect of the land on various bases are really speaking, not parties, but in the appeal which was pending, my lords, before the Chief Commissioner of Appeal or the appellate authority, they rightly or wrongly got themselves impleaded, my lords. I cannot now run away from this fact that they were impleaded. They could persuade the appellate authority to implead them, my lords. They were granted impleadment. And that is how, my lord, they became parties in the writ petition also, and they are parties in the writ appeal also. But so far as the list, my lord, with regard to the sealing proceedings validity is concerned, it is strictly confined, my lords, to the provisions of the Sealing Act, and it is between, my lord, the state on one hand and the landowners on the other hand, which I am representing. Now, if your lordships will be pleased to have a look at the chronology, my lords, your lordships need not go into various aspects of the matter, for the issue is very limited. Now, before I take your lordship, my lord, to the list of dates, may I request Mr. Srinivasa Reddy to pass on the list of dates. Mr. Venugopal, it was the list of dates. So, my lords, what has happened before the learned single judgment order? Your lordships are here. Please to examine the correctness of the order of the learned single judgment order. That's the writ appeal, my lords. It's not an original proceeding. It's an appeal, my lord, which arises out of the order of the learned single judge. The repetition, my lord, was initially in regard to the various orders which were passed in the sealing proceedings. But what happened, my lords, and what has been taken cognizance of, and that's a single premise of the order of the learned single judge, is that in 2008 in Andhra Pradesh, my lords, the Repeal Act was notified. The repeal came, my lord, the central law in 99, but there was a provision that the state authority, the state governments may notify on different dates, my lord. So in 2008, I will give the date later, my lord, precise date. The repeal was notified in Andhra Pradesh, so provisions became. Now, our contention as the landowners was no sooner, my lord, that the repeal provisions became applicable in the state of Andhra Pradesh undivided, that look, we are in possession, the possession has never been taken. And, my lords, if that is so, the saving clause does not apply and the proceedings stand abated. My lord, that became the only critical issue, my lord, a restricted issue before the learned single judge. Namely, whether or not possession has been taken, my lord, during the sealing proceedings. Factually and legally both, my lord, both aspects are relevant. As a matter of fact, whether possession has been taken, and as a matter of law, my lord, whether possession can be said to have been taken, my lord, because there are certain preconditions, as, my lord, are laid down in the Act, and, my lords, the Supreme Courts and High Courts have, my lords, dealt with those preconditions, my lord, for taking over a possession. On both the counts, my lord, the learned single judge, my lord, found in our favor that possession has not in fact been taken, my lord. It only looks like a paper possession, my lords, under a cover of pancharama, and physical possession has remained with the landowners. Consequently, as a natural corollary, my lord, the sequel of the finding is that the proceedings stand abated. And, my lords, from that point of time, the land has to be restored to the landowners. my lords, in innumerable cases, my lord, the Supreme Court and your lordships have decided. I'm aware, my lord, the Chief Justice also has decided, my lord, Justice Shampu also, number of such cases, my lords, they are occurring every often. This is the background, my lord. So, your lordships are only concerned in this appeal 508, where they find the learned single judge. And basically, my lord, having regard to the scope of the intra-court appeal, my lord, which the Supreme Court has indicated, is that is the finding of the learned single judge that possession has not been taken over, both factually and in a lawful manner, is such a perverse finding, my lords, that would shock the conscience of your lordship, my lord, and your lordship would exercise the intra-court appellate jurisdiction, my lords, an exceptional jurisdiction, to upset the finding of the learned single judge or reverse the finding of the single judge, and that your lordship would be willing to do, my lord, only when you are satisfied that the finding is absolutely perverse, no reasonable prudent person would have, on the basis of the materials that existed on the record, taken this, my lord, view or recorded this finding of possession. That's it, my lord. That's the scope. The rest of the issues are not, my lord. If the state, if, my lord, other societies, other persons have a claim, my lord, and their applications are pending for regularization before the state government, my lord, that's a different cause of action, my lords. They have to take recourse to law if they can. If they have acquired title, my lord, then only they can. But, my lords, as far as this is scope, this writ appeal or writ petition's scope is concerned, it is only confined to the aspect of examining, my lord, whether the proceedings under the Sealing Act, by virtue of the Repeal Act, my lord, has stood abated or not, my lord. That's all. Now, with this background, my lord, if I may quickly take your lordship through the list of dates, then, my lords, the only certain dates or events become relevant for your lordships to examine are not the entire gamut of, my lords, the history or the events. Kindly have a look at the list of dates, my lords. I hope your lordships have been given.
Yes.
Yes. So, my lords, it is like 1976, my lords. It all started in 1976. And the Act also came into force, the Sealing Act. The writ petitioners, namely, my lord, the respondents 1 and 2, my lords, before your lordships in this appeal, they filed their declaration under section 6(1), my lords, because it requires filing of a declaration, my lord, if a person is holding land beyond the limit, my lords, in regard to the vacant land, my lord. Then 2, my lord, the proceedings pursuant to the declarations filed, proceedings were, my lord, registered. Proceedings number B2 upon 11240 of 76 dated 24/2/93 passed by the special officer, my lord. By the orders passed by the competent authority, special officer under land ceiling Hyderabad, without going any, it was held that first writ petitioner. Please see, my lord, it would be little necessary to know. First petitioner is Manubhai Patel, my lord, Manubhai Patel, holds an extent of land of 19,933.95 square meters, out of which the surplus has been declared to an extent of 18,375. So his total holding was 19,933, out of which it was declared, my lord, as 18,375 is surplus. And please see, my lords, that the lands are located in survey number 2224 and 2362, my lord. There will be some importance to this survey numbers. When your lordships would be examining the question of possession, etc., my lords, this will assume significance. So, survey number 2224 and 236/2 in so-and-so village. And that order, my lords, of the special officer is at page 80 to 86, my lords. It's not necessary to read those orders in detail, my lord, but it's an admitted fact. Proceedings, my lord, then B2 upon 11241 and the order dated 17/2/1993 was passed by the special officer. The competent authority Hyderabad, by the order they held second writ petitioner holds an extent of 21,630 square meters, out of which the surplus has been declared an extent of 20,368 meters in survey number 2224 and 236 upon 2 of so-and-so village, my lord. So there are two orders, where, my lords, the two writ petitioners declaring land surplus out of their total holdings. Now, my lords, we are not happy with this order, these orders, my lords, of declaring surplus. So we filed a statutory appeal under section 33, my lords, at serial number 4. The first petitioner filed appeal under section 33 of the ULC Act before the ULC Chief Commissioner, who is the appellant number 1, my lords, in this appeal, in the month of March 1993. And second petitioner also filed appeal on the same day. So, my lord, both the petitioners filed appeals, my lords, under section 33. Now, serial number 5 is the most important, my lord, fact, and has a lot of bearing, my lord, upon the issue of taking possession. On 16/4/1993, my lords, the appellate authority passed an interim order on 16/4/1993. The appeal was filed by one as admitted. The special officer is instructed to maintain a status quo as on 13/4/1993. The said order is filed, my lord. So this status quo order, which was filed in appeal, is available to your lordships, my lords, at page 134. There is a status quo order, my lords. Now, on 27th of June 2002, these appeals were disposed of, my lords. In the first instance, the two appeals that we filed, both the appeals so were disposed of by common order by the Chief Commissioner of Appeal under ULC. The said appeals were disposed of without going any opportunity to the appellants who are the petitioners, and therefore the said dismissal orders 27/6/2002 were questioned by way of writ petition before this honorable court. So the appellate authority, my lords, dismiss our appeals, against which, my lords, we filed writ petitions, that is WP number 18851, against the dismissal of the appeal of 2013, my lords, that the writ petitions filed by the petitioners questioning the dismissal of appeal and other proceeding before the Honorable High Court, dated WP 18851 of 2003, and the said writ petition was admitted and the interim order was granted by. So, my lords, the learned High Court, my lords, when it entertained the writ petition, also granted interim order pending disposal of the writ petition. So earlier, my lord, there was a status quo order granted by the appellate authority, which survived between, my lord, 1993 to 2002. And 2003, when, my lords, the appeal were filed, there was again an interim order by the High Court. Now, WP MP number 2353 of 2003, in WP number 18851, while the writ petition 18851 of 2003, the status quo orders were granted by the Honorable High Court on 17/9/2003, and the interim orders passed by the Honorable Court on so-and-so date, my lord. So 2003, there is an interim order. Then on 29th of June 2005, the third respondent, my lord, the special officer or the competent authority who is conducting all the sealing proceedings, my lord, he is the concerned officer, has filed counter in WP 18851 of in which the third respondent is stated that aggrieved by the order of SO and CA, both the declarants have filed appeals before, and the status quo orders were passed on 16/4/1993, and the said appeal number so-and-so were dismissed on so-and-so date. Idea of mentioning this, my lord, fact is this counter, the passing of the status quo order in appeal on 16/4/1993 has been admitted by the competent authority. He does admit that there was a status quo order. Then, my lords, WP number 18851 of 2003, final order was passed on 8/8/2005. Our writ petition was allowed by the learned single judge, my lord. The writ petition filed by writ petition number so-and-so 18851 was allowed by the Honorable High Court, and on 8/8/2005, Setting aside the order passed by the Commissioner of Appeal in without which dismissed our appeal and remanded the matter back to the Appellate Authority, Commissioner of Appeal for fresh disposal after hearing both the parties and further directed that the status quo existing as on that day shall be continued till the disposal of the appeal. So, my lord, he had granted the status quo. It was, my lord, in operation during the pendency of the writ petition. He further, since he remanded the matter, he said that the status quo order will continue during the pendency of the appeal. Then, my lord, while appeal was pending now, having been remanded, my lords, it is a claim, my lord, which we have of course not admitted, that on 20th/5/1994, a notice under section 10(1) was issued allegedly, my lords, to Sri Manubhai Patel, that is the first writ petitioner. So there is a lot of, my lords, this interplay between who was given which notice, who was not given, my lord, certain notice. So this 10(1) notice was given to Manubhai Patel, my lord, that is the first writ petitioner. But the fact remains that no such notice has been received by the writ petitioner, and the government has not filed any proof of service on the writ petitioner. Moreover, the status quo order in favor of the writ petitioner by the Appellate Authority on 16/4/1993 were enforced. Therefore, the alleged notice in 10(1) is in violation of the order of status quo. So, my lords, having said all this thing, my lord, what really, my lords, is striking is that 16/4/1993 status quo order, an admitted fact, during appeal, my lord, when this status quo order was, my lord, in force, 20th May 1994, my lord, it is alleged that the notice was given under section 10(1), my lord, which is clearly in the teeth of the status quo order, if at all factually given, my lords. We do not admit that it was factually given. Then 6/8/1994, again the same situation prevails, my lord. In regard to section 10(3) notice, the further proceeding under subsection 3 of section 10 issued by the competent authority, my lord, which Mr. Prasad, my lord, says that by this notification the land has wasted, my lord, are fabricated and they were not served on the petitioner, and the government also did not file any proof of service of the notice, and the said notices were prepared and filed in writ petition and are contrary to the status quo orders passed by the Appellate Authority on 16/4/1993. Therefore, all proceedings in Panchanama and so are non-est in the eye of law. Then, my lord, there comes the, during the pendency of appeal, Panchanama 4/11/1991. My lord, that's the entire, my lord, the plank of the argument that position has been taken. That is so-called Panchanama, my lord, said to have been prepared on 4/11/99. The Panchanama dated 4/11/99 was fabricated, one, and two, by an incompetent person alleged to have conducted the Panchanama. Furthermore, the MRI, that is Mandal Revenue Inspector, who is said to have taken possession over the extent of so and so meters of land, large chunk of land below 96,479 square meters below, over and above our land. It was further stated in the Panchanama that extent was covered by structures and was handed over to him. And also the Panchas who were shown in the Panchanama were stated to be laborers, and they are from far away from the land situated in so and so village. One of the Panch who was stated as laborer has signed in English, and all these things clearly show that Panchanama is a fabricated document brought in existence illegally, my lord. Lordships will see this Panchanama later, my lord, at page 179, etc. In fact, my lord, so two or three things, my lord, apart from this factual dispute, and my lord, which the learned single judge has found, that it becomes very suspicious, this kind of a, my lord, Panchanama in cyclo-styled format, my lord, filled up in only in handwriting, is again, my lord, when the status quo order was in force, 16/4/1993. The status quo order by the Appellate Authority was in force, and there were interim orders subsequently by the High Court also.
What is the date, status quo order dated?
16/4/1993. The appeal was dismissed in 2002. So, my lord, this is all during my lord's the time when the appeal was pending and the status quo order was in operation. Everything, whatever, my lord, assuming what Mr. Prasad has said is, my lord, to be accepted for a while, at 10 was given, Panchanama was prepared, but this is all happening, my lord, when the status quo order is in force. In the fact that Honorable High Court WP 7762 has given a direction twice to they produce the original records remain pertaining to those service of notice under section 10.1, 10.3 and Panchanama conducted thereon. Well, that's of very, very crucial significance, Millards. The learned single judge has noted in his order that he asked repeated Millard directions to produce the original records, and they just did not produce Millards for obvious reason that if they had produced, adverse inference would have been drawn. There was something amiss in the records. And Millards will also appreciate one more fact, 7762, when we came finally, Millard, to the High Court. The competent authority, Millard, who is the concerned authority officer conducting the sealing proceedings, his records are in his court, Millards. He did not even file a counter affidavit, Millard, in this. Did not. That's also noted by the single judge. He did not file a counter affidavit. There are some, Millard, very stark features of this case, Millard, which appeal to the learned single judge, Millard, to hold that the actually position has not been taken. Then the reply affidavit filed by the petitioners in WP 7762 of the 2007 in the month of 2000. In the reply affidavit, the petitioners clearly taken a stand that the government did not take any position under the alleged and fabricated Panchanama and also the proceedings under section 10.1, 3 and 6 were bogus and created one the said relevant portion of the pleadings are at so and so paragraphs. Now, why, my lords, in our reply affidavit, we said that for a purpose, and the purpose was, my lords, that in April 2008, the repeal was notified in Andhra Pradesh state. Repeal. So, my lord, that made it necessary for us to categorically assert in the affidavit that position has never been taken physically, my lords, and it has remained throughout with us. So that is, my lord, which I will refer to this affidavit later on. Then, my lord, on 28/9/2007, counter filed by the respondent number 20. Now, here comes, my lord, a private society called, my lord, this Tirumala Venkateshwara Society. So, respondent number 20, my lords, in this case, a private entity, my lords, he files a counter because he was successful in getting himself, my lord, itself pleaded in before the appellate authority. So the counter is filed in the writ petition, my lords, and I will deal that case of respondent number 2 little later, my lord. But, my lord, respondent number 20 also, my lords, said that the physical possession was not taken. My lords, I will refer to that. He also, my lord, to that extent, he is, my lord, with us. We are sailing in the same boat. We are on the same page. They also assert that possession was not taken, my lord. Then, my lord, what happened on 15/12/2006? My lord, can you see the 16, serial number 16 in the array of dates? The appeal, the appellate authority dismissed our appeals. My lord, your lordships would just recall that the appeal which was remanded by the High Court, he finally, my lord, dismissed the appeal. He said that parties are not appealing, so he scrutinized the records. 2006, he says that he has seen the entire record, the original record, and the proceedings are, my lords, upheld. My lord, when I will show to your lordship this order, this impugn order out of which this WP 7762 arose. The order is passed in 2006, my lord, but crucially, very significantly, my lords, none of these events, my lord, the alleged events like issuing notice under section 10.1 or section 10.3 or 10.5 or 10.6 or Panchanama are mentioned in the appellate order, my lord. Or the appellate order very categorically, my lord, formally says that he has perused the entire records, but these proceedings are not mentioned, my lords, in his order, the appellate order. Then please turn over the page, my lords. During the pendency of the writ petition, so, my lord, this Repeal Act came into force, repealing the Urban Land Ceiling Act for the state of Andhra Pradesh, with effect from 27th of March 2008, while notification dated 22/4/2008. So, my lord, the repeal comes into force. 22nd of April 2008, with effect from 27th of March 2008. And I say, my lord, in fact, no counter affidavit has been filed by the special officer under ULC. However, in the counter filed by the appellate Chief Commissioner Land Administration, that is the appellate authority, he has not disputed the orders passed by him in appeal in the first instance of the status quo order dated 16/4/93, and also the status quo order granted by the High Court on 17/9/2003, and the final orders passed on 18/2005. He did not even ever, with regard to the proceedings dated 10/1/10/3 and 10/6, there are no documents for supporting the contention. My lord, it's a bit curious case, my lord. In fact, in my my lord's very modest experience, my lord, I have not come across that where the original authority who is really concerned, my lord, and who should be assisting the court, does not file the affidavit. But the appellate authority, my lord, files a counter affidavit. Appellate authority, my lords, has only to decide the appeal, and the moment he decides the appeal, he becomes functions of issue. So, my lord, formally, so the appellate authority has chosen to file counter affidavit, but not of much assistance in any case. And here, my lord, the appellate authority has also filed a rate appeal, my lord, of course, along with this. My lord, how much, my lord, really it will head to justice, my lord, but then to me it sounds little, my lord, strange that the appellate authority, and in my understanding, my lord, the appellate authority has only to decide the appeal. Once he has decided, my lord, he becomes functions of issue. Normally, we don't see, my lord, the tribunals or the appellate authorities, my lord, filing, my lord, they are not parties to the list. Never. So, my lord, now 16, WP 7762 of 2002 was allowed on 29th of April. This is the final order of the learned single judge, my lord, 29th of April 2011. And my lord, he holds that, my lords, the lordships will just see. I have summarized, my lord, the bullet points. At page 19 of the impugned order of the learned special government pleader contended that the status quo order granted by the appellate authority in the appeal so and so on no position was taken over in respect of the land so and so. Then page 17, 18, my lords, I'll, my lords, place these paragraphs, my lords. Now, my lord, when the writ appeal is filed, my lords, obviously there is an interim order in the writ appeal after we succeeded in the writ petition. My lords, the societies who claim, my lord, to have acquired interest in the land, which was subject matter of sealing proceedings, have also filed appeals, my lord, because the effect of the order of the learned single judge is that sealing proceedings have abated. And obviously, my lord, the landowners are entitled to the land. Now, if I may, my lord, before I deal with, my lord, the main submission, my lords, I just want to clear one aspect of the matter so that, my lord, that area is clear. Respondent number 20, my lord, which is the society, and my learned senior colleague, Mr. Reddy, my lord, very vehemently, my lord, pursued the case on behalf of respondent number 20. Now, who is respondent number 20, my lord? Let me tell you, lordships, very briefly. If your lordships will turn to page 164, my lord, of the paper book in this 508. 164. This is, my lord, the case. Of course, there is a separate appeal, my lord, but his case is my lords, stated in this counsel affidavit, so I would rather like to refer to this, and that would be convenient to your lordships as well. So page 164.
164.
Yes, my lords, of the 508 paper book. I'm very glad, my lord, to hear that from 1st November, your lordships have become e-court completely, my lords. I came to know about this, and all the records are digitized. So page 164.
It's my copy. Which appeal? 508. Correct.
164 page.
One. Yes.
Yes, my lords. Please see paragraph 1, my lords, that I am president of 20th respondent herein, Sri Tirumala Venkateshwara Cooperative Housing Society, Hyderabad, and so and so. Then para 3. The brief facts of the case are that the first petitioner and 4 others, first petitioner means Manubai.
One. Yes.
Yes. First petition and 4 others entered into an agreement of sale with the society on 22nd of March 1982. An agreement of sale, my lord, there are some calling rates, sale deeds, etc. Respect of land measuring area acres 13.10 guntas in survey number 2224, my lord, please note that, survey number 2224. So, my lords, they claim survey number 2224, so part of it. It is submitted that owners jointly made application for change in the land use, no problem. 5, my lord, then again the owners and the society made application to plan the layout, etc., my lords. Then para 5, fourth line, your lordship will see, it reads, it is submitted that owners did not come forward for execution of sale deed in favor of the society and created some problems as the society has compelled it to file a suit for specific performance, while OS number so and so of 93, and the said suit was decreed on 14/11/2003 in favor of the society. It is submitted that an appeal by CCCA number so and so and cross appeals are pending. Now, my lord, while this appeal might be pending, but it is a fact on record and brought on record, my lord, that the special performance decree which was granted by the trial court has been reversed by the High Court. That decree has been set aside, against which, my lord, a special petition was filed in the Supreme Court, and that special petition has been withdrawn, my lords. And from my experience of being here in the Supreme Court for 20 years, I can say that we as lawyers, my lords, withdraw the special petition only when, my lords, we are not lentiers, my lords, or the judges are not inclined, the court is not inclined to, my lord, entertain it. So, my lord, the fact remains, the judgment of the first appeal, I'll give the details of that judgment, my lord, it is somewhere on the record itself, of the High Court in appeal has become final. So, my lord, the very genesis of, my lord, the claim, an agreement for sale, on basis of which a decree was passed for a specific performance, that decree has been reversed, that goes, my lords. That is why the other day, my lords, I said that I have a serious objection to the locus of R20, my lords, and there was a reason. I was making a very responsible submission on that day, my lords, that the locus disappears, my lords, after the High Court has set aside the judgment, and the agreement remains agreement, my lords. There is no transfer of the land. If on the basis of the agreement they have applied to the state government for regularization, etc., my lords, it is there, my lords. Let's say we do not, but they cannot claim anything, my lords, in our land. That's a different cause of action altogether, my lord. They have this, has no relevance here. And likewise is the situation of the other societies also, my lords. The various other societies have been rising before your lordships, my lord, to say that we have purchased and we have purchased. So no sale deed has been executed, my lords. So having cleared this, my lords, if I then can take your lordship to the impugn order briefly, and then the support for that impugn order to show that the findings are absolutely justified, my lords, of the learned single judge. Please come to the impugn order, my lord, at page 18. Page 18, my lords. In earlier pages, my lord, the learned single judge has given the entire history, my lord, from beginning to end, my lords, to this filing of the writ petition against the appellate order dismissing the appeal. But there is, my lord, an event which takes place, my lord, and the learned single judge was required to take cognizance of that. That is the Repeal Act, while the writ petition was pending. Your lordship said page 18, my lords.
Yes.
Yes. During the
Yes.
During the pendency of this writ petition in the month of March 2008, the government of Andhra Pradesh repealed the ULC Act which came into force from 27th of March 2008 by way of a notification issued under GO number so and so. The department dated 22nd April 2008. Therefore, the petitioners contended that all the proceedings have been abated. But the special government pleader said that so far as the first petitioner is concerned, an extent of 18,375.29 square meters was not taken over the possession by the authorities. Please note that, my lord's statement. So it is now, my lord, contrary to what my learned friend Mr. Prasad argues here, my lords, very categorically stated that so far as the land of the petition number 1 is concerned, the surplus land, 18,000 was not taken over possession by the petitioners. My lord, this has been elaborated elsewhere also, my lords, I will refer to that. So I think, my lord, it becomes very clear, and it's a matter of fact from the record, nobody has questioned the correctness of this submission, that so far as respondent number 1, Manu Bhai, is concerned, it is the state government's own case that the possession has not been taken over. And what really makes it interesting, my lord, is this, that even if we have to give, my lord, some credence, my lords, only for the submission purpose, it was given, my lords, the record which has been filed in the appeal, my lord, record was not filed before the single judge. A notice was given to Manu Bhai on 31st of August 1999, my lords. That is page, you will see the notice at page section 10.5 notice, page 177, my lords. Page 177, dated 15/7/1998. This purports to be a notice under section 10.5 given to Manu Bhai according to them, my lords. The learned single judge has not accepted this because there is no proof of service, my lords, or dispatch or service. Your lordships were also going through the records the other day. The assistance of my lord, Justice Shavit Kumar. It's in Telugu. But there is no, lordships noted that there is no proof of, my lord, dispatch and service of this notice. It's just, my lord, on record. Now, this is, my lord, addressed to Manu Bhai Shankar Bhai Patel, 10.5 notice, which has been consistently held, my lord, right from Hariram and before. There is a condition precedent, my lord, that you have to first give a notice and then take possession. So, Manu Bhai, to whom, my lord, the notice is said to have been given, when contrasted with the statement at page 18 of the single judge's order, possession has not been taken. So, the position is, the state government to whom it says that, my lords, the notice was given, the state government says that possession has not been taken. So, my lord, no possession. It's an admitted fact, my lords, not disputed, asserted, my lord, that no notice of two, my lords, the petition number 2 was taken, 10-5. Similar to, my lord, what we see to Manu Bhai. To Nattu Bhai, my lord, there is no notice at all given under section 10-5. But page 18 says, my lords, kindly see, after having said, my lords, the middle of paragraph that possession was not taken, was not taken over, but in respect of the second petitioner, an extent of 20,368 square meters was taken over possession by the authorities. Then the learned single judge says, notwithstanding several opportunities afforded to them in the light of the direction of this court, the authorities have failed to place the original record for perusal of the court and did not choose to even file a counter. That's what the learned single judge records below in the order. But in regard to the possession claim, my lord, responded 2 is concerned, petition number 2 is concerned, Nattu Bhai. The special government pleader says that it seems that possession has been taken, but my lords, there is no notice under section 10-5. So it's like this, notice given to Manu Bhai, possession not taken. Possession taken from Nattu Bhai, but notice under section 10-5 not given. That is how, my lord, the position is stand. It is so simple. It is so simple. Then I continue further reading this paragraph, my lords. It says, it is the case of the petitions that there were serious lapses on the part of the authorities as no notice of opportunity was given to them at every stage, more particularly before dismissing the statutory appeals preferred by the petitioners on demand from this court and the order which is now impugned in this writ petition and the light thereof. The proceedings have become inoperative and honest. The order dated 16/4/1993, my lord, the status quo order, which I am referring again, passed by the Commissioner of Land and Sealing, makes abundantly clear that while admitting the appeal preferred by the first petitioner, the order of status quo as on 13/4/1993 was granted. In the counter filed by the competent authority, second respondent herein in WP number 18851, admitted that both the declarants have filed appeals agreed by the order of the competent authority, second respondent before the appellate authority, the first respondent. The said appeals were numbered as so and so respectively. However, they were dismissed on 27/6/2002 at the first instance. In the said counter, it is further stated that no land is in possession and enjoyment of the petitioners as per ground position, stating that during the pendency of the ULC cases and declarants have disposed of the land to the individuals and also entered into an agreement of sale with Tirumala Venkateshwara Cooperative Society and Netaji Nagar Cooperative Society, respondents so and so 19. In the said counter, the government did not claim that the state is in possession. Now, please note, my lord, that in the counter which was filed in the first writ petition, the learned single judge has observed, in the said counter, the government did not claim that the state is in possession of the subject property. The unofficial respondents in their counters also stated that the Panchnama is only on paper and no physical possession is taken over by the authorities. Originally, the appeals were disposed of by order dated 27/6/2002 after a long lapse of 17 years of filing declarations, and the appellate authority dismissed the land, they said, the appeals on the sole ground that the entire area is covered by the status quo order by the court, and the matter is stated to be pending before this court. Being agreed by the same, the petitioners have filed a WP 18851 of 2003 and also challenged the notices under section 10(1), 10(3), and 10(5) dated so and so 15/7/98 in respect of properties held by first petitioner, and also proceedings dated so and so dated 10(3), dated 31/8/98 and 10(5) dated 26/10/1998. The complaint of the petitioner is that the said proceedings were initiated behind the back. No notice under section 10.1, 10.3, 10.5 was served on them. In addition to that, the said proceedings were initiated during the subsistence of the status quo orders granted by the appellate authority. The petitioners stated that they have learned about the said petition only on dismissal of their appeals as such to declare the said petition under section 10.1, 10.3 and 10.5 as null and void. The third respondent filed counter to the said petition and admitted that the status quo order was granted on 16/4/1993. That is the competent authority in the said appeals, and the same were dismissed only on this. The said petition was allowed by the High Court and remanded the matter and to the consider matter afresh. Then the lords will next page 21, my lords. Again, in the middle of the page, the very claim of the petitioners, I hope that, my lord, that's about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. 13th line, my lord, from the top. The sentence beginning with the words, the very claim of the petitioner is that no notice. Lordships could see that, my lords. The very claim of the petitioners is that no notice of date of hearing.
Oh, which internal page, if you can tell us, internal page of the judgment?
21 is the internal page, my lord, 21.
The very claim, yes.
The very claim of the petitioners is that no notice of the date of hearing was sent to them before dismissing the statutory appeals. Though the appellate authority filed a counter stating that the notices were sent, but no material is placed before the court to show that the notice were in fact served on the petitioners. That's, my lord, the finding of the learned single judge. Then, my lords, the last line of this page, my lord, page 21, internal, says, it was further argued that their suit for a specific performance was decreed. However, on appeal filed, the petitioner was allowed by the High Court. So, my lord, by this time, the appeal had been allowed. So, my lord, that fact is noted. Respondent number 20 filed a counter that even though the possession was taken over by the authorities, as per the record, the society and its members are in physical and actual possession with the respective plots at the instance of the society and the lands allotted to APSRTC. My lord, this land was allotted, my lord, that's a subject matter of different proceedings. Then please see, my lord, the notice. That is internal page 22. The notice dated 31/8/99 in proceedings under in so and so, in respect of the first petitioner discloses that notice issued under section 10.5 of the Act expired on 4/9/1998 and directed inquiry officer of the ULC to take over possession under section 10.6 of the Act and hand over the same to the MRO, that is, Mandal Revenue Officer, concerned and report compliances. The consolidated Panchanama dated 4/11/99 reveals that surplus land measuring 96,479.36 square meters, partly covered by the structures handed over by Mandal Revenue Inspector of Asif Nagar Mandal, who is not an authorized person. My lord, authorization is in favor of MRO, but one who takes his, my lord, is MRI. But as per the proceedings dated 31/8/99, the authorized person is the Mandal Revenue Officer, but not the Mandal Revenue Inspector. Therefore, he is not authorized person. Well, in section 3, it is very clearly stated, possession taken over by the state government or any person authorized by the state government. So it becomes very crucial, the difference between MRO and MRI. He is not authorized person to take possession of the subject land, and as such, alleged proceedings are illegal and non-as. In the absence of such authority, it cannot be treated that valid possession is taken. Another aspect of the Panchanama is now, this is very crucial. Now, these are the observations made by the learned single judge having seen the Panchanama. Another aspect is that the Panchanama is cyclo-style Panchanama and blanks were filled up and Panchas namely were shown as R. Malesh, resident of so-and-so Jayaguda, K. Rajendra, resident of Bhargat, and so-and-so Malot, Jayaguda. None of the residents of the so the particular village, Malgudi, Malakapur were called. None from the village, some all from outside. It is not known who brought those panchas from the other areas. Further, the learned council pointed out that the first Pancha Mahesh occupation is shown as labor, who signed in English and also contended that signatures of Pancha witnesses are of the same handwriting, but not all handwriting witnesses are same. On close scrutiny of the Panchanama supports the contention of the petitioners, and further it is not known when the subdivision was taken place, my lord, because a large chunk of land was, my lord, said to have been covered by Panchanama. The second respondent, being the competent authority, did not choose to file a counter to controvert all the allegations. The counter affidavit filed by competent authority in WP, that is the first WP, discloses that the government is not in possession of the land. Firstly, the very notices issued under section 10.3, 10.5, 10.6 during the pendency of the appeal and alleged taking over of the paper possession under a cover of Panchanama is illegal and in violation of the status quo order granted by the appellate authority. Be that as it may, no record has been placed to show that a notice or opportunity was given to the petitioners at the stage of proceedings initiated under section 9.10, 10.3 and 10.5 and 10.6 of the Act, and all these proceedings were initiated behind the back of the petitioners, and therefore earlier a petition was allowed by this court. Even otherwise, while pending statutory appeals, the initiation of the said proceedings are inoperative and honest in the eye of law. Respondent number 20, claiming to be the agreement holder, had filed a civil suit for a specific performance, and the said suit was decreed. However, being agreed by the same, the writ petitioners filed CSCA number so the same was allowed by this court. The unofficial respondents are now contending that the land is vested in the state by operation of law. Respondent 20 and other respondents are claiming that they have entered into agreement with the owner and they now cannot turn around and claim that the land is vested in the government to take advantage of the benefit of GO number so and so. Admittedly, the appeals were dismissed by the statutory authority in 2002 and status quo was enforced during the pendency of the appeal. Therefore, any subsequent steps taken by the competent authority under the Act are non-est and inoperative, while the state of Andhra Pradesh repealed the ULC in the month of March 2008. Therefore, the petitioners are claiming that in view of the repealing, all the proceedings were abated and alleged paper Panchanama dated 4/11/99 is of no consequence as the said proceedings were inoperative and non-est. Alleged proceedings are illegal and non-est in the absence of such authority. It cannot be treated with valid possession is taken over. There is a duplication of the page. Lordships may then come to internal page 27. When the learned single judge takes pains to refer to various judgments, my lords, as were available on that date. Page 28, my lords. Number of judgments are, my lords, page 30, 31. And finally, my lords, in internal page 32, he proceeds to record his findings, my lords. Page 32, as per the facts and as per the law. Lordships have, my lord, page 32.
Yes.
The bottom of the page, my lord, from a conspectus of the law laid down by Supreme Court, including the court and some other high courts in the country, it is clear that when the Repeal Act becomes effective, the proceeding must be treated as inoperative and honest in the eye of law, and the symbolic possession, though unauthorized through unauthorized act of the government having taken over possession of the subject land, is of no consequence. The alleged Panchanama is drawn in respect of case number so and so, so and so, and it was mentioned that wherein possession for an extent of 96,479 meters of structure taken, no notice was issued by the persons who are found to have raised structures. Before taking Panchanama, the land is to be identified and subdivided. There is no subdivision except mentioning in the printed Panchanama that no subdivision numbers were assigned to the survey numbers and no record is placed to that effect. It is evident from the proceedings that no proper notice and opportunity is given at this stage of proceedings initiated under section 9, 10, 10.3, 10.5 and 10.6, and the said proceedings were taken during the pendency of the statutory appeals, and more so when the order of state to SSO is granted. Therefore, the impugned proceedings became abated. As the presidential law relied on by the learned senior counsel for the petitioners are squarely applicable to the facts and circumstances of the present case, inasmuch as the alleged taking over possession of subject land is subject of the second petitioners, while there was an order of status quo amounts to unauthorized act of government, and the consequent taking over of possession, if any, becomes unlawful, taking over possession in a legal manner, have no recognition in law, and it will have to be ignored and treated as of no legal consequence. Further, it is settled law that alleged taking over a possession cannot be symbolical and on paper. The Supreme Court held that in absence of taking over of actual physical possession and payment of compensation, such proceedings will abate. It also held that the act, being an expropriatory legislation, is required to be construed strictly. It was also held that the authority to take possession of the vacant land of the cause is to be given to the state government or to any person duly authorized by such authority, shall be as contemplated under subsection 10(6) of the Act. In the absence of such authority, it cannot be treated that valid possession is taken over. In the present case, the Mandal Revenue Inspector is not an authorized person to take over possession, and even otherwise, as per the pleadings of the unofficial respondent, the possession of the subject land remained only on paper, and the same will lend support to the contention raised by learned counsel for the petitioner that no physical possession is taken over by the competent authority, second respondent. Therefore, all these facts go to show that no legal possession is taken over by the competent authority, second respondent, and the same remained only on the paper, and the said Panchanama and other proceedings were initiated only while pending consideration of statutory appeals under section 33. In the light of the above, our discussion and having due regard to the law laid down by Supreme Court, including this court and some other high courts in the country, the impugned order 15/12 is in appeal by the commissioner of the so-and-so, Andhra Pradesh, and the respondents are set aside, and the sequel thereto, the statutory appeals preferred by both the petitioners are allowed, and the Panchanama is set aside. My lord, this is how. So the sum and substance, my lord, the learned single judge, the load of the order is this, that by virtue of the repeal and by virtue of the fact established before him that possession has not been taken over, physical possession, it's only, my lords, a claim on paper, my lords. The repeal act has become with full force applicable, and the proceedings are abated. Now, if your lordships will see, my lords, page, I'll just show the status quo order, my lord, which is of course an admitted fact, but at page 134 is the status quo order. 134. Running page of the paper book, my lords. The appeal filed by order dates is admitted. The special officer is instructed to maintain a status quo. So if that kind of a status quo is there, my lord, then he was clearly restrained from proceeding with the matter. He could not have issued notices during the currency of this status quo order. Then, my lords, the Commissioner of Appeal dismissed the appeal on 27th of June 2002, page 135. The order of the writ petition, my lord, in the first instance, 18851 is page 139. And the operative portion, my lord, is operative portion of this order is, my lord, page 143. Then, my lords, the counter affidavit of the my lord, the competent authority in the first round of the writ petition, page 145, and kindly see page 146, my lord. 147 first, my lord. Then I'll come back to 146. Page 147, lordship said, my lord, 147.
Yes.
He says, agree by the order of so and so. Both the declarants have filed appeal administration and got the status quo order on 16/4/1993, and the said appeal were dismissed on 27/6/2002. So he admits, my lords, in his counter that there was a status quo order. Then at page 1 of 46, my lord, he tries to suggest is this. 146, my lord, about in the middle of the paragraph, top of the page. The first petition declarant, I hope your lordships get that line below.
Yes, yes.
The first petitioner declarant in CC number so and so declared a surplus landholder to an extent of 18,000 and odd. After allowing 1,000 square meters as retainable area, the second petitioner declarant as surplus landlord to an extent of 20,000 square meters, allowing 1,000 square meters as retainable area. Later on, the above CCs are processed up to section 10(6) stage of the Act and possession taken over on 31/8/1999. Now, please see this, my lords. And that is why the whole thing is absolutely unacceptable. The possession taken over on 31/8/99 under a cover of Pancharama. So his affidavit, my lords, in the first place that possession is taken under a cover of Pancharama on 31/8/99. Now, my lords will see the Panchanama, these melody things, at page 177 is a so-called notice to first only one petitioner, that is Manu Bhai, number 1. And it says, my lord, that now therefore in exercise of power conferred by subsection 5 of section 10, I hereby order you to surrender, deliver possession of the land to Sri Krishnamurti, Deputy Tahsildar of the office. Now here we see Deputy Tahsildar. 10(5). And 178 is, my lords, the order of the proceedings of the special officer. Where he authorizes Krishnamurti, my lord, he says, 10(5), that this time given in notice has expired on so and so, but he failed to deliver possession. Hence, Sri Krishnamurti, inquiry officer of the is authorized to take over possession of land under section 10(6) and hand over the same. So 31/8/99, my lords, that forcible possession be taken. Now 179, my lord, is the Panchanama, which your lordships will see, although it is, my lords, in Telugu, and there is a translation also, but on the top of the page, my lords, just below the page number 179, your lordships will find 4/11/99, the date of Panchanama. The affidavit says that the possession was taken on 31/8/99 under the cover of Panchanama. That means, my lord, Panchanama existed on 31/8/99 itself. And, my lord, this is a cyclo-styled form in which, my lords, there are some insertions, like, my lords, the third line and fourth line, 96,000 meters. Now, this Panchanama, my lord, the English translation is next page. And, my lords, page 180, lordships will see, my lord, some writings. It says surplus vacant land measuring 96,479 square meters, partly covered by structures handed over by the Sri Nizami MRI Mandal Revenue Inspector, Azimgad handed on this day. This is my lord, 96,000. Now right hand side says, my lord, surplus vacant land, 96,000 square meters, partly covered by structures, handed over, taken over by me. The possession is as per Panchu. Above possession as per Panchanama, Panchu is. That is MRI. So inquiry officer takes possession, he hands it over to MRI. Page 181, my lord, is the English translation of this Panchanama. What I really wonder, my lord, is this, that if we total of the land, surplus land, my lord, of the two petitioners, 18,000 plus 20,000, 20,000, it comes to about now 38,000. But under this Panchanama, my lord, your lordships are seeing 96,479 square meters of land are taken over in possession under the cover of Panchanama. I don't know how many other lands, my lords, with which we are not. If there is a 10-5 notice, a proceedings, it's only pay, my lord, the individuals, certain individuals. The possession is required to be taken only from them, my lords, to the extent of their surplus land. The surplus land. There cannot be a Panchanama, my lord, will be overreaching, my lord, over encompassing, my lord, 96,000 whose land. This is not the way, my lord, the possession is taken, my lords, in terms of the provisions of 10.5 and 10.6. Maximum, my lord, the surplus land is approximately totaling of both petitioners is 38,000. And here, my lord, the possession is taken of 96,000 square meters. And there are structures also, my lords. To whom those structures, where is the notice given to them, my lord, to those, my lord, structures? So obviously means some houses or, my lord, dwelling houses or houses. Where is the notice to them all, my lords? So this kind of a Panchanama cannot, my lords, really, the court of law, with great respect, my lord, will find it extremely difficult to countenance this kind of Panchanama. And then based on the state's huge claim, my lord, big claim that possession has been taken. That's the only document, my lord, that document.
96 looks. So includes goods. Goods segments. They have taken. Ask him.
Sir, if you see the Panchanama proceedings.
Yes, sir.
Page 181.
Yes,
They're referring to different survey numbers of different extent to 6 others also.
Yes.
So probably they may have taken Panchanama, this land, as in one lot.
Lord, that precisely is my that precisely is my
Because, 1 minute, because you were making submissions on the extent of the areas. Please see the proceedings.
Yes, my lord, the Panchanama proceedings, my lords, refers to different survey numbers also, my lords.
And 6 others.
Six
So
others.
probably they met, but we don't know what happened to the fate of other 6 others.
Don't know, my lord.
6 others.
But my respectful submission is this, my lords, that the proceedings, sealing proceedings are qua, my lord, the party, a party. The possession proceedings will have to be qua a party. Supposing, my lord, 18,000 square feet has been declared as surplus. There has to be a notice, my lord, or Panchanama proceeding, or, my lord, some paper has to be prepared. Qua, my lord, that area only, there can't be a clubbing of the area, my lord. That shows that this was done in a most mechanical manner, my lord, that somebody prepared this Panchanama in the office. There has to got to be separate Panchanama, where, my lord, each my lord, the landholder owner from whom the possession is taken. And it is not necessary, my lord, that for every piece of land, the landowner himself is in possession. On his behalf, others may be in possession. They are also required to be given notice. This Panchanama says, my lord, that there are structures, partly covered by structures. Now, whose structures are there, my lords, in this? So, my lord, when the totality of this is seen, my lord, this Panchanama is very, very, my lord, unsafe for any court of law to record a finding that on the face of
25.
Panchanama, my lords, the possession has been taken. No conclusive finding can be given, my lords, on the basis of this in favor of the state government. And the onus, my lord, in the context of the Repeal Act, is on the state government to establish before the court that possession has been factually taken, and not only factually, but it has been taken lawfully also, because there are condition precedents, my lords, for taking over a possession. Certain compliances are to be made, like Hari Ram's case. So this Panchnama cannot, my lord, therefore be of any assistance, my lord, to the state government to establish that possession actually has been taken. It leaves lot of suspicions. My lord, it leaves several questions, my lord, which are unanswered and which cannot be answered, my lords. And there is no other material, no other document, my lord, except this. That possession has been taken, except this Panchanama. There are two different conflicting dates, my lords. The first affidavit says that possession was taken on 31/8/99 under cover of Panchanama. Whereas we find, my lord, the document, it is 4/11/99, and there is no notice.
Yes.
My lords, I then have to show to your lordships, my lord, some provisions of the act and I don't think that being the limited issue, my lords, I need to go to various other things. Yes, my lords, yes, please see, my lord, now there's something important. Page 194, my lords, of the paper book. When I invoke the repeal provisions in my favor, my lord, I invoked it after 2008. The affidavit that I have filed, my lord, is here. At page 195, 194 is the affidavit. I must give the date of this affidavit, my lord. It is sometime in August 2010, August 2010. And I invite your lordship's attention to page 195, my lord, the bottom of the page. The rest is all history. I submit
Yes.
the lordships at page 195, my lords.
Yes.
The bottom of the page, my lords.
Hmm.
I submit that petitioners are in continuous, uninterrupted physical possession and enjoyment of the subject matter of the land in survey number 2223, 2224, 2225, 236-2 situated in village so-and-so, Asif Nagar Mandal as absolute owners. Therefore, the allegation that in pursuant to order under section 10(6) of the ULC dated 31/8/99, the ULC authorities have taken possession of the land and handed over the same to MRI by conducting Panchanama on 4/11. It is a typographical mistake. Is totally false and as such denied. No possession, much less any physical possession, is taken under the said alleged Panchanama. The said Panchanama is a bogus and created one. In fact, the unofficial respondent therein, in their counter affidavit, categorically stated that the said Panchanama is only on paper and no physical possession is taken. The fact remains that the alleged Panchanama is only on a paper and created at the office of the second respondent, but no physical possession was taken over. In fact, there is no subdivision amongst the writ petitioners and their family members as the same as joint family. Further, the MRI has no authorization to possession of the state government as he was not authorized and contemplated under section 10(6). It is further submitted that due to illegal interference by the district collector and Tehsildar, the writ petitions have constrained to file. Now, this is very important, my lord. Writ petition number so-and-so, wherein this honorable court was pleased to permit the petitioners to fence the land in survey number 2223, 2224, 2225, 236-2, and so on, by an order dated 16/1/2010, passed in WP number 11 of 2010. Further, the Tehsildar Asif Mandal by later dated 21/12/2009, in letter addressed to Station House Officer allowing the fencing in the retainable area to an extent of 4 square meters to avoid encroachment. Accordingly, the petitioners have fenced their land. The district collector filed a counter affidavit wherein he admitted that in pursuance of the directions granted by the High Court on 6/1/2010, petitioners have fenced the vacant land. Therefore, the allegation that land is wasted in the state and the possession is taken over under a cover of Panchnama is false as derived as stated above. The petitions are physical and effective possession of the subject matter of land as absolute owner. At no point of time their possession was disturbed by the authority. Therefore, there is no merit in the counter affidavit and hence it's allowed. Now, my lord, what more really is required to prove my possession, my lord? The High Court grants me an order for fencing my lord this area, the land in question, and I have fenced it, my lords. When the fencing takes place, my lord, these are clear, my lord, evidence of the fact that I am in possession, and that fact is admitted. Shall I continue after lunch? Your lordships rise at 1:30 for lunch or later, my lords?
Yes, 1:30.
I'll take about 20 minutes more, my lord, 20 minutes or half.
All right.
Place the act and some decisions, that's all, my lord.
Yeah.
సుదర్శన్ రెడ్డి గారు మీ టైం పడుతుందండి మీ అప్పీలు.
Good afternoon, Reddy sir. Good afternoon.
Good afternoon, sir. Good afternoon.
సుదర్శన్ రెడ్డి గారు నేను పద్మని మాట్లాడుతున్నా. మీకు అప్పీల్ టైం పడుతుందా అండి మీ కేసు?
పడుతుందండి, టైం పడుతుందండి.
Has been allowed by this honorable court in the year 2005. In fact, has been dismissed for default because the order seems to be not correct, which is fine. Lordship will, I leave it to my lord, but just to verify from the office which order is correct. Because according to the record, online status, Justice Ramesh Srinivasan dismissed it for default. But the order which is enclosed is of Justice TSHC Reddy, which records as if the repetition has been.
Which case, WP?
The writ appeal which is now being argued, urban land ceiling.
Ah.
In that period, I found out just now, my colleague has found out. From the record, there are the writ petition which is said to be allowed, in fact was dismissed for default. It is at page 154.
Like the order in WP number
18851 of 2003.
No, 7762. What is
the earlier writ petition 188, which actually was the writ petition which was allowed, setting aside the proceeding of the Commissioner Appeals. But 18851 of 2003
record, madam. We will get the record.
Yes.
Get the record of this. What is the, let him continue. We'll find out what is the record.
Yes.
You give the number, WP number.
18851 of 2003.
Get the record, madam.
Date of order it's here shown is 8 August 2005.
And where is the order allowing the writ petition?
This is the order allowing the writ petition. Which
this is means where?
At page 154. 154 of the paper.
154 in which appeal, Mr.?
508 of 2011, which the state has.
154, yes. Huh? This interim order?
No, but 154 is the WP order which is allowing the writ petition.
This is 28th August 2005.
Yes, sir.
8th August 2005, it says, page 154.
8th August. 8th August 2005.
And page 159 is the operative part of it.
He says that this petition, in fact, has been dismissed for default.
My colleague has just found out from him.
When?
I can't
10 to 2011.
10 to?
2011. Its online status shows so.
We'll find out. We have sent for the record. We'll find out what has happened. Yes, Mr. Please.
Now, only as far as possession is concerned, my lords.
Oh, 1 minute, Mr. Shiva. So give us 2 minutes. There is one matter. Yes. Yes, Mr.
Page number 19 is a covered order.
19?
Yes.
All right. Yes, Mr. Disposed of. Yes.
Your lordships will see page 248. This is, my lord, the only affidavit available from the competent authority in regard to possession. page 248, a very small sketchy affidavit.
Yes.
And if your lordships will please turn to page 249, it refers to the repeal provisions. In the middle, I respectfully submit that on repeal of the ULC Act, the government issued certain instructions, then they are quoted. And 250 millards will see, it is submitted that in the instant case the possession of the land is taken over under section 10(6) of the Municipal Act, Panchanama dated 4/11/99 enclosed. That's all. Now, this is too vague a statement, my lord. This is not how the courts are assisted on the most critical issue of possession. When was the notice issued? When was it served? How was it served, my lord? So nothing is there, my lord. No proceedings. A straightway or statement, my lords, that possession has been taken. So now, my lords, as far as the facts are concerned, I have placed, my lord, the learned single judge's order also and the other supporting facts. Now, let me, my lords, take your lordship, my lord, very quickly through the provisions of the Land Ceiling Act, because they have some bearings as far on the claim of having taken possession. Can we have section 9 and 10, my lords? So,
Urban Land Ceiling.
Urban Land Ceiling Act.
Yes.
Section 9 and 10, my lord, I'm referring to. Now, other sections are not relevant at the moment. So, section 9 is about the final statement, where after the return is filed, final statement is contemplated under this section. So, that's all. Then section 10, acquisition of vacant land in excess of ceiling limit. How does the acquisition take place? Once the land has been declared as surplus, the next step is to acquire it, my lords. Acquisition can be by law also. So, number 1, subsection 1, as soon as maybe after the service of the statement under section 9 on the person concerned, the competent authority shall cause a notification giving the particulars of the vacant land held by such person in excess of ceiling limit and stating that such vacant land is to be acquired by the concerned state government. The claims of all persons interested in such vacant land may be made by them personally, to be published for the information of the general public in the official gazette of the state government in such other manner as may be prescribed. So that is the first step, my lord. Then subsection 2, after considering the claims of the persons interested in the vacant land made to the competent authority in pursuance of the notification published under subsection 1, the competent authority shall determine the nature and extent of such claims and pass orders as deems fit, my lord. That's all. Then subsection 3, that is the vesting provision. At any time after the publication of the notification, under subsection 1, the competent authority may, by notification published in the official gazette of the state concerned, declare that the excess land referred to in the notification published in subsection 1 shall, with effect from such date as may be specified in the declaration, be deemed to have been acquired by the state government, and upon the publication of such declaration, such land shall be deemed to have wasted. So, deem acquisition, deem wasting, absolutely in the state government, free from all encumbrances, my lord. So, that is the wasting part of the scheme. Then 4 is, my lord, the restraint on the alienation, etc. I can skip it over. Then subsection 5, after, my lord, there is a deemed wasting, deemed acquisition followed by deemed wasting. Then, my lord, the next step, my lord, is then taking over a possession, my lord, how? Now, subsection 5, where the vacant land is vested in the state government under subsection 3, the competent authority may, by notice in writing, order any person who may be in possession of it to surrender or deliver possession thereof to the state government or to any person duly authorized by the state government in this behalf within 30 days of the service of the notice. So subsection 5 contemplates, my lord, either surrender or peaceful delivery of possession. Hari Ram's judgment, my lords, which I shall place, my lords, are aware, has very, my lords, analytically analyzed the provisions of the. So this contemplates surrender or peaceful delivery of possession. Then kindly see, so, my lord, there is a requirement of a notice under section. The machinery for taking possession is set into motion only by issuance of a notice under section 10(5), which Hariram has said, my lord, is mandatory. Then subsection 6, my lord, if any person refuses, so there must be a refusal. Firstly, section 10(5) notice is issued, served, then there is followed by refusal, or fails to comply with an order made under subsection 5, the competent authority may take possession of the vacant land or cause it to be given by the concerned state government or to any person duly authorized by the state government in this behalf, and may for that person use force as may be necessary. So Hariram has described, my lord, this provision of subsection 6 as forcible taking over a possession. That's the scheme of the act. Then also see, my lord, the repeal act then. In the same, I think, Bear Act volume, my lord, your lordships will get the repeal act also. And in case it's a universal Lexus Nexus, my lords, then page 854.
Yes.
So it's a repeal of, it was, my lord, a 1999 act, but subsection 2 left it to certain states, my lord, to adopt it by resolution. And section 2, Urban Land Ceiling Act is hereby repealed. Then 3 is saving, my lords, the saving provision. The repeal of the principal act shall not affect the wasting of any vacant land under subsection 3 of section 10, possession of which has been taken over by the state government or any person duly authorized by the state government in this behalf by the competent authority. So if the Pradesh where the wasting has taken place and possession has been taken over, my lords, then the repeal will not affect. Subsection 2. Then, my lord, section 4, abatement of legal proceedings, all proceedings relating to any order made or purported to be made under the principal act pending immediately before the commencement of this act, before any court, tribunal or authority shall abate. That's the schema. Now, my lords, there are some judgments, my lords, your lordships will find guidance from the judgments of the courts which are rendered over a period of time by different high courts and the Supreme Court as well. My lords, may I request Mr. Venugopal or Mr. Srinivas Reddy to hand over the case note. My lords, I have made a case note. Mr. Venugopal or Mr. So, my lords, just to assist your lordships, my lord, quickly, there are captions given, my lord. First is possession on paper is merely a symbolic possession and will not amount to actual possession, my lords. And the judgments which, my lords, throw light on this are, the first is the state of UP versus Hariram. Then, my lords, there is an Andhra Pradesh judgment and Karnataka judgment and so on. Now, if the second caption is, my lord, if the possession of the land has not been taken over by the authorities concerned prior to the repeal act, all proceedings shall abate, my lords. So Bashir is the case, my lord, the leading case on this. Then other Kostner versus so and so, Vinayak case, my lords, Justice Lodha's judgment, Pandit Madan Swarup Shruti, my lords, judgment, etc. Now, my lords, then your lordships will turn over the page. And the bottom of it, my lords, there is some disarray in the arrangement of the topics. Then the second page, my lord, the bottom of the page, possession taken without following mandatory procedure as per section 10(5) and 10(6). Now, this issue has been examined, my lords, in Gajanan Kamlai Patil, Mullah Bai, my lord, that's the High Court judgment of Madhya Pradesh, Manoj Patel, and Lakshmi Kanta, it's some Andhra Pradesh judgment, my lords. Now, what I have done, my lords, after this index is given, then your lordships will find the page case note. So I have extracted, my lords, the relevant holdings or the relevant paragraphs from those judgments, which are there, my lord, my lord, from all these judgments. That's, my lord, to make it easy because I know your lordships are so much burdened with the work. This is how, my lords. At the same time, the copies of the judgments are also there. So, my lords, this is the arrangement. Then coming back to the index once again, the top of the second page, top, my lords, the topic is interference with administration of justice is contempt, nullity, my lord, that's violation of the court's order. And the law is very well settled, and very recently, my lord, judgment by His Lordship Pardiwala in this Balwant Bhai case, that any act or action which is in violation of the court's order is a nullity, my lords. That's it. Then the second caption is about intra-court appeal, my lords. Your lordships are well aware about the guidance from the Supreme Court that unless there is a perversity, my lords, in the order of the single judge, otherwise it's intra-court appeal, my lord. It's not in hierarchy from a subordinate court to a higher court, my lord, a superior court. Now, my lords, I wish to place, my lords, two judgments, my lords, that is Hari Ram's judgment, my lord. And in a sense, my lord, if I may say about this judgment by Justice Radhakrishnan and Deepak Mishra, that, my lord, has become a locus classicus, my lords, on this issue of interface between the repeal provisions and the Padeshan issue, my lords. And if your lordships will turn over, your lordships have the judgment, my lord, Hari Ram.
Yes, yes.
Kindly come straight, my lord, to the paragraph. My lord, 31 in the page 296, my lord, the report, page of the report 296. Where three types of, my lords, handing over and taking over a possession is described.
Item flag. Flag. Yes.
So, my lords, if I may take your lordship to para 31 at page 296 straight. So, first is voluntary surrender. Your lordships noted in section 10(5), the order may require the person in possession to surrender it. So, my lords, that has been dealt with. Then para 32, my lord, says something important. We are of the view that so far as the present case is concerned, the word wasting takes in every interest in the property, including de jure possession and not de facto, but it is always open to person to voluntarily surrender and deliver possession under section 10(3). But that's not the case here, my lord, that the government has pleaded that there was a surrender of the possession. Then the next, my lord, para 34 is peaceful possession. And if I may read para 35, my lord, lordship say, if de facto possession has already passed on to the state government by the two deeming provisions under subsection 3 of section 10, there is no necessity of using expression where any land is wasted under subsection 5 of section 10. Surrendering or transfer of possession under subsection 3 of section 10 can be voluntary so that the person may get the compensation as provided under section 11 of the Act early. Once there is no voluntary surrender or delivery of possession, necessarily the state government has to issue notice in writing under subsection 5 of section 10 to surrender or deliver possession. Subsection 5 of section 10 visualizes the situation of surrendering and delivering possession peacefully, while subsection 6 of section 10 contemplates a situation of forceful disposition. Para 36, the Act provides for forceful disposition, but only when a person refuses or fails to comply with an order under subsection 5 of section 10. Subsection 6 of section 10 again speaks of possession, which says that if any person refuses or fails to comply with the order made under subsection 5, the competent authority may take possession of the vacant land to be given to the state government for that purpose. Force as may be necessary can be used. Subsection 6 therefore contemplates a situation of a person refusing or fails to comply with the order under subsection 5, in the event of which the competent authority may take possession by use of force. Forcible disposition of the land, therefore, is being resorted to only in a situation which falls under subsection 6 and not under section 5, section 10. Subsection 5 and 6 therefore take care of both the situations, taking possession by giving notice, that is peaceful disposition, and on failure to surrender or give delivery of possession under subsection 5, then forceful disposition under subsection 6 of 6. The requirements of giving notice under subsection 5 and 6 of section 10 is mandatory. Though the word may have been used therein, the word may in both the subsection have to be understood as shall, because the court charged with the task of enforcing the statute needs to decide the consequences that the legislature intended to follow from failure to implement the requirements. Effect of non-issue of notice under subsection 5 or subsection 6 is that it might result in the landholder being dispossessed without notice. Therefore, the word may has to be read as shall. Then, my lords, may see para 42 and 43, my lord, effect of repeal. Para 42. The mere wasting of land under subsection 3 of section 10 would not confer any right on the state government to have de facto possession of the vacant land unless there has been a voluntary surrender of vacant land before 18,399. The state has to establish, so my lord, this is what I was emphasizing. It is for the state to establish that there has been a voluntary surrender of vacant possession land or surrender and delivery of possession under subsection 5 of section 10 or forceful disposition under subsection 6 of section 10. On failure to establish any of those situations, that is, my lord, where the state government fails to establish this, the landowner or holder can claim the benefit of section 4 of the Repeal Act. The state government in this appeal could not establish any of those situations, and hence the High Court is right in holding that the respondent is entitled to get the benefit of section 4. We therefore find no infirmity with the High Court's judgment, my lords. So, my lords, I'm nearly saying possession has been taken, my lord. There are a lot of things, my lord, under section 10.5 and 10.6 required to be brought before the court, my lord, in a fairly convincible manner, except saying that under a cover of Panchanama, my lord, that's all. So, my lords, this is the law, and it has been followed, my lords, consistently, my lords, by all courts, and even subsequently by the Supreme Court by saying that where, my lord, a notice is not given under section 10.5 for that notice, admittedly here it is given to petition number 1 according to state, but his possession has not been taken, his possession of his land has not been taken. That's what page 18 of the single judge's order reads. And, my lord, to the petition number 2, no notice has been given. That's the state's own case. And possession, they say that possession has been taken. That possession is not a lawful possession, my lords. So, my lords, this is the totality of, my lord, the scene before your lordship, my lord, so far as this is concerned. And, my lords, now, while concluding, I only submit with greatest respect, my lords. I am not questioning your lordship's jurisdiction in the division bench as an appellate forum, my lord. But your lordships do observe restraint, my lord. Some my lord, limitations are there. And Justice Korean Joseph, my lord, said that unless the order is found to be perverse on the face of it, my lords, the rule of, my lord, caution in the exercise of intra-court appellate jurisdiction is not to interfere, unless your lordship will, my lord, be convinced that a very manifest injustice or miscarriage is caused, my lord, by perversity of the conclusions recorded. So that's my respectful submission. So far as private parties are concerned, I have demonstrated, my lord, they are strangers to the property as far as the repeal provisions are concerned. It's a matter between us and the state government. Whatever are their rights, my lord, they may have or they may not have the forums, my lord. They must go to those forums. They can't interject, my lords, in this appeal and have it decided. If the learned single judge has declared that the proceedings have abated and has quashed the order, my lords, they can't say no, the proceedings have not abated, my lords. This is And my lords, I only respectfully submit that so far as the first writ order is concerned, although my lord, a surprise has been sprung just now by saying that the petition was dismissed. But that order has been filed by the state government itself, my lord. It's not an order filed by us, sir. I know that that's an undisputed position. The appeal was
Record.
and the appeal was allowed, and therefore, my lord, the matter was remanded. Even the appellate authority in the second round notices, my lord, that the matter has been received on remand, an appeal, and he has decided. I don't know, my lord, how it is being suggested that petition was dismissed. So, this is what all my lords, I respectfully submit that the learned single judge's order is a proper order, my lord. It is a well-considered order. This is essentially finding a fact which has been recorded by the learned single judge based on the materials available. And the state government has a lot to say, which it did not say, my lord. So the latest the writ appeals, my lord, may be dismissed, my lords.
Yes, Mr. What do you say?
But sir, may I have it, my lord, sir? May I have your lordship's leave, my lord, if your lordship?
Yes.
I'm so
Yes.
Prayer in the writ petition, my lord, I just reply, my lord. Page 39 of the paper book. Page 38 of the paper book, 508 of 2000.
What is it?
Prayer says, my lord, to set aside the proceedings passed by the appellate authority, dismissing the appeals. There is no prayer to any challenge to the Panchnama as such. The learned judge has also said the Panchnama, which is also held to be bad by the learned single judge. That was not the scope of the writ petition also. The other aspect, which was being canvassed.
1 minute. Page 38.
The prayer, may I read, may I read the prayer notes? Particularly in the nature of the to call for records relating to connected to the orders of first respondent, the appeal number so and so, dated so and so, covering both the orders of second respondent proceedings, dated B12 76, dated 17 to 93 and 24 to 93, twice the same and declaring the land petition 7 number so and so, measuring so and so, respectively agricultural land, even otherwise appropriate provisions of the UNC Act. But this is the prayer, Lord. If your lordships kindly go to the relief granted in the writ petition, relief.
So relief has been granted, which was not even asked for.
Yes. The other, one more aspect I wanted to clarify, I have also given the gist which has actually been misplaced. Now it traced out my lordship's record. There were 5 declarants in all. 5 declarants, 2 are before my lords, 2 are before the authority. Other 3 are not challenged. They were happy with the declarations which have retained finality in respect of the property.
No, but they are like joint owners or what?
No, kindly see different map. There was a division made between the family members. Map was filed. Kindly go to the list which I have filed. Different file numbers were also given. Extents and different file numbers.
That's all right. So there were yes.
Yes. Total extent of your lordship. Total extent.
3 members of the family are not challenged.
Yes. The one more aspect. Kindly see the total extent which I have indicated was 1,14,780 square meters. But out of this extent, what was argued by predecessor, my lord, saying that an extent at page 16, which was recorded by the learned single judge, in view of the status quo granted in respect of a single appeal by the appellate authority, we could not take possession of the extent of. Kindly see at page 16, my lord, of the running paper.
Status quo was in respect of how much of?
In respect of one appeal 76, if I am correct, appeal 76, filed before the commissioner. Kindly see at page 16, my lord, the predecessor of mine has argued before this court, before the single judge, saying that 18,379 square meters as there was taken over for respect of land in extent of it, as there was no status quo order granted in respect of the appeal filed by the second petitioner. Content status quo order granted in appeal by the first.
Tell us in respect of how much area there was no order of status quo.
20,366. Possession, next 3 lines. Possession was taken in respect of land of second petition extent of 20,363. 366.83 square meters. Since this was not forming part of the status quo order, this was the contention raised before my lords. earlier which I cannot now, my lord, go back on that. But the other aspect is not the societies which I have argued before my lords, not bringing to my lord's notice that they have purchased the land, for lordship to consider. And because they have.
So please tell us status quo was in respect of how much area?
18,375.29.
18,000?
375.29 square meters. Which we have not taken possession is the argument advanced also by the learned Don Bidder earlier, appearing earlier. I cannot, page 16 is recorded by the learned single judge.
Possession not taken.
Yes, that area position was not taken. But
So
I want
remaining area it was taken.
Yes, but I wanted to clarify with it. Showing the extent is 1,14,780 square meters. Why I am pointing out is, if your lordships go to the Panchanama, but it indicates that 96,000 odd square meters is taken possession of, deducting this 18,000 square meters. Panchanama also indicates the fact. I'll just point out from the paper book, Panchanama. At page 179.
Page
179. The English is at English version is 181. 181. Kindly see, Bharat. I'll just read. Be the above three panchas on a call duty from Deputy Tehsildar and Inquiry Officer ULC Hyderabad are present on the spot at land in survey number so and so. As if at the above place, Deputy Tehsildar and Inquiry Officer ULC taken possession of land under section 10(6) of the ULC Act to the extent of 96,479.36. But this is out of 114 minus 18,000. I have also indicated in my written note, this extent and the position which is taken. I have drawn out the extract from the Panchanama for the convenience of the court. Other aspect is possession being argued before my lords, where possession being a seriously disputed question of fact, cannot be gone in 226 for my submission, relying on State of Assam versus Bhaskar Jyoti Sharma, which your lordships have already considered earlier also. May I request one thing, if your lordships give me a day's time, I'll just pass on this note and judgment.
No, but we will, you can give it tomorrow.
That's my sir.
We will reserve and.
Just for this, the point of position.
All right.
In the recent.
You can give a note. Mark the presence, everybody.
The other request which I made, just for your lordship's perusal.
We are getting the record. We are getting it.
That goes to the root of the matter.
Coming? 5 minutes also you told me on the way. Record must not be there.
There's no appeal. There is no.
We wonder. I don't know. We have sent for the records. We don't know whether we'll get it or not. Under the rules, probably 3 years old record has to be destroyed.
But this copy has
and I've been told. No, but you have acted upon that order. Your authorities have, after that order of remand, have passed a fresh order. We will. It may be a subject matter of inquiry. Is it your case that somebody has forged this document, the respondents, and signed the signature?
If the order is not in place, then the entire validity will be there in respect of taking over possession of the land. That was the first challenge made.
No, but see, if you are serious about it, then don't, leave it to us.
Yes.
Then you file whatever.
But since I am not privy to the record, just my colleague, Mr. Kiran, found out in there. That's the reason.
There has to be some mistake, right? There is an order, right, signed. It is nobody's case that it is forced order or something.
But I thought it's my duty to bring it to my lord's notice and leave it there.
Madam, get the record. Coming means where it has reached. Coming left the section. No. File traced out, not traced out.
Message that we had given attended, I don't know if it's on the day. Just a message.
File traced out, right?
Yes.
So you tell no. Don't show it to me. You tell that the file has been traced out, it is being sent. Fine.
I'm obliged.
Get it. Get the record. Will 1 minute let.
I'll be.
The file is on the way. So
be-
let's see within how much time it reaches. So that you also see what is there.
As
Go
an
through.
as an officer of the court, I thought that I should.
No. Correct, but we should be able to know what is there. Well, record like from where it is coming.
My lord, I'll just make one submission for your lordships and leave it, my lord.
Ah.
Two clarifications from what the learned senior judge, my lord, senior advocate has submitted to your lordships. If your lordship will please to take, my lord, page 153 for once, my lord, in writ appeal 657. What was brought to your lordship's notice is that, my lord, there was an interim order from this honorable court, and by virtue of that interim order, they have fenced the land. My lord, that writ petition was, my lord, WP 11 of 2010. My lord, in which, my lord, a counter was filed and a vacate was filed by the writ appellants in, my lord, WP writ appeal 657, and also, my lord, by the state. The state's counter, my lord, would be more relevant for your lordship's consideration at page 153, my lord.
The WS 657.
Writ appeal 657, my lord, grateful to your lordships. Page 153, my lord. My lord, sir.
Yes.
My lord, 153 at 153, if your lordship is pleased to see, the writ appeal number is 11 and a vacate stay is filed, my lord, by the state also. Overleaf at page 154, my lords will please to see. This is the counter filed, my lord, by the collector, and my lord, after this vacate stay petition was filed, my lord, writ petition was withdrawn. Page 154, my lord. Second line. The special officer and competent authority, Urban Land Seal in Hyderabad, passed final orders on under section 8.4 declaring an extent of 1,14,078.84 square meters as surplus, and out of the said land, an extent of 94,479.36 has been taken possession by the ULC authorities after issuance of notice under section 10.5 of the ULC and handed over to the second respondent on 4/11/99 for safe custody. Since the said land is in possession of the second respondent, the allegation made by the petitioners that the respondents are interfering with their possession is totally incorrect. That's how, my lord, they obtained an interim order. It is further submitted that out of 5 declarants who have filed declarations in the above survey numbers, only 2 petitioners are before this honorable court. The first petitioner filed declaration in WP 1112470, declaring an extent of 19,933.95 in survey number 223-224. And the second petitioner filed declaration via declaration 11241 of 76, declaring an extent of 22,257 in survey number 225 by 5. These 2 petitioners were declared surplus to an extent of 18,379 and 20,368 square meters respectively, allowing retainable area of 1,558 square meters and 1,889 square meters respectively. Therefore, the petitioners are in possession to an extent of 1,558 and 1,888, totaling 3,447. Hence, the allegation made by the petitioners that they are in possession of 15,000 square meters is totally incorrect, which they pleaded in the writ petition. The writ petitioners filed false statements before the respondents 2 and 4 herein, stating that they were allowed retainable area of 15,229 square meters by the special officer and competent authority, Hyderabad, and there are two wells in an extent of 1,103 square meters, servant quarters to an extent of 1,125 and an extent of 2,933 square meters.
Let him. Yes.
My lord, overleaf, if your lordship will please to see, the allegation made by the petitioners that the Mandal surveyor, page 155, my lord, that had surveyed the property is also not correct. The ULC authorities who have taken possession over the property to an extent of 96,479 after following the due procedure by issuing notices under section 10.5, 10.6 of the ULC Act, handed over the same to the second respondent for safe custody as long back as on 4/11/99. Therefore, the Mandal surveyor has no business to survey the said land. As seen from the records, the petitioners herein did not produce the subdivision sketch prepared and issued by the urban land sealing authorities along with their representation, seeking for fencing of retainable area. The second respondent ought to have requested the ULC authorities for the said sketch, but instead has directed the Mandal surveyor to survey the said land and prepare the subdivisional sketch with regard to the retainable area of the writ petitioners. Mandal surveyor, who has no role to play in the present case, has prepared.
Madam, give it to him, record. Yes.
But showing the excess lands taken over by the ULC department as retainable lands of the petitioners. Basing on the same, the second respondent addressed a letter to the fourth respondent requesting them to allow the petitioners herein to fence the retainable area as claimed by them. On coming to know of the said incident, this respondent, that is the collector, has initiated disciplinary proceedings against the Mandal surveyor and also against Vijay Chandar, who is the second respondent herein. The second respondent is issued with charge memo, and whereas the Mandal surveyor is suspended pending inquiry. It is further submitted that pursuant to the interim directions granted by this Honorable Court in WP 11 dated 6/1/20, the petitioners have fenced the vacant land which has already been taken over by the state under the ULC Act, claiming it to be in their property. My lord, overleaf also, my lord, the special officer said, you are never in possession. 11, this interim order which you obtained in WP 11 is by misrepresentation to the Honorable Court and playing, my lord, my lord, with the officers concerned, and the officers concerned were also taken to task. My lord, we have also pleaded about that in the writ appeal. My lord, if your lordship be pleased to, my lord, take page 10 for page 9 for once, para 10, my lord. The writ appeal papers itself, my lord, page 9. After a vacate and counter were filed, my lord, they withdrew the writ petition. Para 10, my lord.
Mr. You be rest assured, we are not recording a finding in this appeal whether they have fenced the area or not. We will not do it. Our scope is confined to examining validity of the order of learned single judge. That's it.
So,
yes.
My lord, since the learned senior counsel brought to your lordship's notice that government were also.
That's why we are clarifying it. We can't prevent anybody from arguing. So that's what we are telling you. We will not record a finding in this appeal whether or not he has fenced the area.
No, my lord. Also, your lordship will also, my lord, incidentally look at the equities, my lord, and the conduct of the, my lord, the writ petitioners. Para 10, my lords will please to see for once, my lord, para 10, my lord. That would show their conduct. While pending the writ petition, para 10 at page 9, my lord, the first respondent, along with their owners, by suppressing the proceedings and taking possession of the surplus land by the fourth respondent, and by playing fraud on the court, obtained the interim order to fence the retainable land in WP 11 of 2010, dated 16/1/2010. It is submitted that under the guise of the said ex parte order, the respondents 1 and 2 illegally tried to encroach into the petitioner society land covering 49 plots. However, immediately on coming to know the same, these appellant society filed implead and vacate sections in the said writ petition. The appellants 1 and 2, without intimation, withdrawn the WP 11 of 2010, and accordingly the same was dismissed. Thus, any interim order passed in WP 11 deemed to be vacated, and any benefit obtained under the said interim order has deemed to be nullified. It is submitted that the land covered by under 49 plots, which is subject matter of GO 640, has not fallen to the share of respondent 1 and 2 and not computed to their holdings. Thus, they are no way concerned with the set deadline. My lord, insofar as the prayer is concerned and the order, my lord, which was granted by the learned single judge was brought to your lordship's notice. That itself, my lord, would be perverse. My lord, one other aspect only, my lord, your lordship will please to see at page. My lord, the possession was taken in 99, which my lords will get at page 125. One of the grounds raised is that it was not taken over by the inquiry officer. It was taken, possession was taken by the inquiry officer only. My lord, your lordship will get at page 125. Though it is in Telugu, overleaf, if your lordship will please to see at 126. My lord, on the left-hand side at the bottom, my lord, the possession is taken over by the inquiry officer of the ULC. Handed over for safe custody, my lord, to the Mandal Revenue Inspector on the right-hand side. Possession was taken, my lord, by the competent authority only. And, my lord, to these proceedings, possession of 1999, my lord, 2002, my lord, land was allotted, my lord, to the RTC. The respondent 1 and 2 did not raise their, my lord, small finger also for the reason that the possession was taken and they acquiesced themselves, my lord, to the possession taken over by the government. That are the two judgments, my lord, which I have circulated to your lordships. The note is also circulated to my lords, my lord, on that. Obliged. My lord, one other part, one aspect, my lord, page 40, my lord, the possession, the writ appeal is filed only by two declarants. My lord, the entire possession is set aside. Page 40, if your lordship will please to see. Appeal is filed by only two people. Writ petition is filed by only two people. Proceedings insofar as the other five are concerned have become final. My lord, the learned single judge, my lord, contrary to the prayer which is read to your lordships by the learned government pleader, by the learned senior counsel also appearing for the state. My lord, if your lordship will please to see at page 40, in the light of the above, the discussion and having due regard to the law laid down by the Supreme Court, including these court and some other courts in the country, the impugned order dated 15/12/2006 passed in ULC Appeal number 59 by the Commissioner of Appeals, Office of the Chief Commissioner, Andhra Pradesh, Hyderabad. The government herein is set aside and sequel thereto the statutory appeals preferred by both the petitioners. Well and good, my lord, that would be different. Under section 33 stands allowed and the Panchnama is set aside. The Panchnama to the extent of entire thing is set aside. My lord, insofar as we are concerned, my lord, our land falls in the other people and, my lord, to the extent of the surplus of the respondent number 1 alone. Land which was given to the RTC. We protected it, my lord, by coming before this honorable court. I read to your lordships the writ petition order of the learned single judge, writ appeal order, and the review order passed at, my lord, page 147. Therefore, my lord, the order of the learned single judge, my lord, has to be set. Obliged.
Yes. Oh. Yes. Arguments heard, reserved for delivery of judgment.
Obliged.
But the Learned Senior Counsel, he also wants to submit the written submission within 3 days.
Huh? No, not 3 days. You do it, Mr. He said tomorrow.
Yes, we also want to, day after tomorrow, your lordship, 2 days within.
Why 2 days? I mean, this is like coming up on a Monday. Give it tomorrow. What is there? Everything has been.
Yes, my lord. Your lordship. That's quite a lot of that. Obliged.
Yes. You can, madam, 1 minute. Yes.
The original suit, my lord, suit filed for declaration of title and injunction.
Ah. Yes.
My lord, originally, my lord, suit 629 of 1990.
Get prepared. You told us that.
I've
Where is it?
circulated. On 10/7, 12/10/2023, we have circulated.
12/10.
12/10/2023, my lord. అది కాదమ్మా ఇది ఇట్లాంటిది ఉన్నది. It's happened that. Let's. Let me take page 6 of this synopsis, my lord. There are two first line, my lord.
So what is page?
Page 6, my lord. There are two.
There is no
There are two, my lord.
Ah.
But OS number 629 of 1999 and OS number 630 of 1999 on the file of Honorable Chief Justice City Civil Court, Hyderabad was filed seeking the relief of declaration of title and perpetual injunction in respect of plots in survey number 179 of Jemastanpur village. The above suits were decreed by common judgment dated 26/2012. Impugning the above judgment, the decree and the present appeals were preferred by the government. My lord, the suit scheduled properties, my lord will get it the page 135 is the plaint. These suits were filed against the government, my lord, stating that the government is interfering with the private property in survey number 179, which is the offshoot of, my lord, CS 14 of 1958. My lord, the preliminary decree was passed on 28/6/1963. My lord, wherein certain assignments are purported to have been made in favor of defendant number 32. And the legal heirs of the defendant have given their rights in favor of the Nizam. Nizam in turn has, by virtue of a registered deeds, has given it to one Cyrus Investments. They come into the record, my lord, by filing appropriate applications, they were impleaded. And my lord, from there on, my lord, this suit starts. The commissioner has prepared a partition of the possession of the properties and carved the layout. In that layout, my lord,
What basis declaration was sought, Mr.
And a
Not
sale deed.
saying anything, right?
Lord, on a sale
Just
deed.
like whatever.
Well, sale deed has been
The suit has been filed, what ground?
basing on a registered
So
sale.
will you tell us?
Yes, that's what. Well, basing on the registered sale deeds, well,
This
they say
is,
that
this is first appeal, right?
true, my lord. First appeals. That's the reason I'm
So
trying
like
to
not
explain.
anything like whatever it feels you feel like, say something and sit down.
No, my lord. I'm not on that, my lord. My lord,
Not on
page,
the-
page 135, my lord. Page 135 is the plain. Their narration I'm trying to explain. They say that by virtue of the assignment of the land from CS 14 preliminary decree given to their vendors, they have purchased the property. That is how they are before the court. Page 136, my lord. Para 10, my lord, para 137. Straight away, my lord. The title itself, my lord, para 10, page 137.
1 minute, Mr. Permit us to please sit down. We will go through if you have written something. Otherwise, we will have to see the plaint. What are the averments? This all irrelevant table. PEGA, what is PEGA? What is PEGA? Brief note on PEGA. CS 1440s. Identified as PEGA. Gotcha. So what is the case? Like, I don't understand.
What basis this suit was filed when the final degree proceedings were still
pending, Milord. Still pending. Milord, one crucial issue what I'd like to present, Milord, in the
This is
preliminary
your appeal,
judgment.
right?
What is it?
This is the state appeal.
Yes, Milord.
So, when the matter is sub judice in CS 14,
yes,
how this went ahead? How this matter went ahead?
That is what our grievance is, Milord, before the court. Court felt, Milord, since the possession has been given by the High Court, and so also the warrants were issued in execution proceedings. Milord, the court felt, Milord, that since the position is there, title can be given. That is what one paragraph, Milord, which says in the other.
We will go into that in detail.
Yes, sir.
Now, since the entire CS 14 matter is pending, and the final degree proceedings are also pending.
Yes, sir.
Now, any finding given in this appeal, would that not amount to contradictory findings?
My lords,
what should be done? Should we hear the first matters pertaining to final decree or this?
May I answer this way, my lord? Since the judgment of 1963 excludes this particular property, my lord, no decree can be passed on this, my lord. That is what I am trying to explain.
This property is not there in 1963.
Item 29, Schedule 4 is not part of the preliminary decree judgment, and so also in the decree. That's all I can explain in 2 minutes, my lord.
Then why it is tagged with CS 14?
My lord, since it's the offshoot of CS 14, my lord, it has been tagged that way, my lord. That's all, my lord. If my lord go to the judgment,
where is the preliminary decree? Where is the preliminary?
826 is the judgment passed in CS 14, 28/6/1963. My lords may take up the 826, my lord, page 630. If it is not there in the schedule, sir, nothing more.
Preliminary decree, this particular schedule of see, first appeal, it should tell us that here no declaration. What is the claim? Where have you said in this pages that what is the plaintiff's case?
I said so.
We are trying to look
Page
into
18, my lord. Page 18. It starts with page 14, my lord. I'll say so.
Yes. You want to say something?
Before my girlfriend commences in detail,
Ah.
let him tell the history of CS number 14 with reference to the records. Because we are in the first appeals.
Ah.
Then pleadings, what is the oral evidence, what are the findings of the lower courts, and what are the grounds raised, and what are the points
That's
to be
what
raised.
we are trying to understand. What is the pleading? He is not telling us. He is jumping here and there.
41. And what are the points to be considered ultimately in the appeal? All those things must be placed before the court.
You advise your young friend to how to argue.
CS number 14 of the history must be known first to this court. We are only saying something outside like that. That has not happened like that. It is judgment of the Supreme.
We will have the benefit of hearing you also. Please explain. Now, what we can't teach him how to argue.
I'm just pointing out to you, Lord.
Please appreciate. We are also trying to understand what is. I'm telling my brother that he has so far he has not said anything. What is plaintiff's case? What basis? What has happened? What was their defense? Pratik? Yes. what can be done? We can't teach him how to argue first appeal. We will have the benefit of your assistance. You please argue, explain to us, let him, what can be done? He is free to proceed in his own way. Go ahead, whatever you want.
I apologize for this.
No, Mr. Please don't be under an impression. The final hearing cases, we don't read it. Motion hearing, you can depend on us that court will find out a point in my favor and grant relief. This is final hearing. We don't have any idea. What is this case about this thing? And this is the first appeal. Is this the way to argue? I mean, your senior has told you. What? We can't teach you how to argue first appeal. Go ahead, whatever you are saying. Just like extempore some sort of thing and sit down by 4 o'clock. Rest the court will do.
Lord, may I explain it? Lord, the plaintiffs are claiming their title to their vendors who are the assigned.
Where is the plaint? Orally saying will not help, Mr. Orally.
135 of the paper book, my lord, that has been circulated to the court. OS number 629 of 1999, page 135, my lord.
Or should we hear him first? Then you argue like.
If my appeal, my lord, let me explain. Let me have the satisfy your lordship on this issue, my lord.
Okay.
Plaint starts at page 135, my lord. The narration starts.
The only thing is, Mr. You should realize you are here to assist the court, right? And this is a first appeal. It's not a question of satisfaction. You should really assist the court.
Yes, ma'am.
In this thing. We are telling you this is a final hearing matter. We have not read it. I don't have any idea about this case.
I moved on to the court's observation, my lord. I'll
No, final hearing, nobody reads. At least I have not read. Motion hearing, you can bank upon me that the court has read. Court will pass an order, whatever it feels like. That you can bank upon. This is a final hearing. You. Yes.
The claimant raised the title through one Cyrus Investments, who are the plaintiffs in the next suit of 62630 million. This comes, my lord, at page 136 of the plaint. Plaint starts at 135. Page 136, now the narration starts at para 1. Para 1 speaks about, my lord, the Paiga history and how, my lord, suit was filed in.
What is Paiga?
My lord, the Paiga during the Nizam's regime, my lord, the militaries were given to maintain to the private persons, my lord. They were maintaining the military and defense establishments of the Nizam. And for them, there were certain grants were given. There were 3 Paigas altogether during the Nizam's, my lord. In one among them.
You ask him. Ask him, is it part of CS? Other company.
Sir, see, what is coming in our mind is since it's CS14, the report is not yet filed. It is in the stage of final hearings. Decrees have to be drawn. Hearing this matter may have an effect, have a bearing on those matters. See, once the report is filed, that we will be giving opportunity to file your objections, because this is the part and parcel. According to you, is it a part and parcel of the CS14?
It was a part of the property, item number 29 in schedule 4 of that suit. Now, what happened, my lord? If your lordship permit me, I will tell the background, entire background of the case. Because my
we are not going immediately into that.
No, what is happening is.
No, we are only trying to, whether it can be heard. That's the thing. Otherwise, we invest time and this thing, and then later find it can't be heard. That's what.
No, these properties are not involved in the final degree proceeding, other proceedings now. Because if in a partition suit, there can be any number of preliminary decrees, any number of final decrees. That is what has happened in that suit also. It's a partition suit. And state government was not initially party to the suit. Later on, only the Jagir administrator was made defendant number 43. Later on, the government was implicated. Why I am pointing out, Maladi?
It can be heard.
The state government, state of Andhra Pradesh was implicated because there were two properties, Hafiz Pet.
Again, our question is, before going into the merits, do we have to hear this first? Or should we hear, make a...
These appeals can be independently heard, Maladi.
So are you saying that it is not part of CS 14? Please confine to that submission.
No,
because this order should not have bearing on those orders.
This property was a part of the CS 14 only.
So we deem it appropriate. We deem it appropriate to hear once the report is filed.
There are several reports have been filed by receivers of commissioner based on.
If you're aware, this court has appointed a new set of receivers. We're expecting the report.
No, my lord, what happened?
Benefit may be given to.
Then you lordship may direct the receiver come commissioners to produce all those records. The CS 14 records will be there. I have filed several records of CS 14 also. Subject to what you lordship direct, because I can show from the records.
Sir, we have appointed a new set of receivers. We are expecting the report.
All right.
Once the report is on record, let an opportunity be given to all, to everybody to examine it and file your objections.
In that event, I have my submission, one submission, my lord, that the receivers give notices to the advocates who are involved in different properties, so that we will be able to point out all those
And
details.
eventually that will be done once the report is on record. It is in that stage. The earlier reports with this court is, whatever has happened is happened. We have appointed a new set of receivers. So this observation should not be contradicting, whether we can hear this matter unless both the parties are agreed.
There won't be any contradictory things, my lord, that I will be able to point out, because subject to what you lordship say, my lord, there won't be anything contradictory. Several final decrees have been passed in respect of several items of the properties in this matter. That's why the problem is. And in this, so far, this property is concerned, Jamistan property is concerned, there was a finding on issue number 10 by the court, High Court, while deciding the matter. It is not a compromise decree as my learned friend has been putting it. Partly compromise, partly based on the contest. Government participated. They produced evidence. They cross-examined witnesses. Their written statement I have filed before the court as a mark as exhibit. All that was considered, and court held that this property belongs to particular persons. It was never a part of Matruka property actually. Because they agreed to compromise, all right, this may be taken into consideration, division among the sharers, all that happened there. Those findings are also recorded there. That's why the whole problem. Oh, we can point out. अच्छी बात है, ठीक है. Let them some time limit in that event.
We will record their submission. That it will have no bearing on civil suit. You ask both of them.
So, see, we can hear this matter on one now. Let's both come to a consensus that whatever is the finding recorded in this appeals will not have any effect on the CS 14. So with that premise, we'll go ahead.
We can.
No, it's your submission, right? We will record it. Both the councils submit that it has nothing to do with CS 14.
One submission I take, one submission. So both the suits, my lord, and the claim of the plaintiff is the offshoot of the decree, my lord. That's all I can say, not beyond. Because one submission, why I'm saying that, my lord, is by virtue of the judgment at page 724 is the schedule that is given in the decree that is passed. This item number is missing, my lord. It's not there. And this is found correct to be correct even by the Supreme Court. So this particular item is not there in the schedule. That is all I'm saying, my lord. 724, my lord, one line I'll show, my lord. Page 724 of volume 1. This item 29 of schedule 4 is not part of the judgment and it is not a decree at all. And this.
So therefore, there should be no difficulty, right? If we say that it has no bearing on this thing. It has nothing to do with civil suit, whatever 14.
CS 14 of 19.
14. That is the joint submission. We will record and go ahead. It has nothing to do with CS 14, right?
Let me run with that. I am pointing out, if your lordship reads issue number 10 decided by the, in the judgment.
No, what is your submission, Mr.? We will go to issue everything. What do you say? It has nothing to do. It can go ahead. We can go ahead.
Your lordship can proceed with this matter independently. There won't be.
No, your submission, Mr. We have not, after spending 4 hours, we find that the subject matter is the same. Therefore, we are asking you at the beginning.
Well, no doubt this was a part of the property which was.
No, he says not part, no part of the property, he says. This is not a part of the property of civil.
Item number 29 of schedule 4. Let the registry produce that schedule 4 before the court here, because they are not giving certified copies of those schedules. I have made certified several applications, certified copy applications pending. It won't give that. There is a finding recorded by the court below. High Court.
Okay. They say it is not something, it's a totally different. So this is not part of CS 14, right?
This property of Jamistapur was item number CS 14 was there. There's no doubt about that.
Let's clarify again one sentence that clarifies.
There should be no this thing, right? Whether or not this, the question is, this is part of CS 14. I mean, how can there be different views on this that no, it is part of CS 14? He's saying not part, you are saying it's part of CS 14.
Lordship takes up the judgment delivered by this honorable single judge to try to issue to the original side. The matter would be clear. Issue number 10.
I'm speaking from the same judgment, my lord. 724, the schedule, my lord. I'm not going beyond that, my lord. One sentence that
Kindly
show that this item 59, schedule 4 is not part of this judgment. The item 29, schedule 4, page 20, 724, my lord. The tabular column.
Where is 724?
Volume 1, my lord.
Volume 1.
I've circulated the volumes also.
What, it must have been digitized, right? No.
Only in the mood volume system. 3 volume.
Yes, Mr.
वन में देखो जजमेंट किस में है पेज नंबर उसमें जो जजमेंट का पेज निकालो 258
Internal page 458.
To which he is referring to schedule.
Schedule, my lord. Internal page 458, my lord.
TC 458. Schedule is given. Is it there?
Schedule, internal page 458.
458. TC
28.
Schedule starts at 456. Schedule starts at 456. And the relevant section is 458.
458.
Yeah.
458, sir.
We are not getting 458, Mr.
458.
What is the internal page of that document, if you can tell us? Judgment.
456 it starts, my lord.
Internal page, if you can tell, because it's not tallying with. Internal page of the judgment.
My lord, this internal page of judgment I'm saying, my lord, 456.
456.
Last schedule, the judgment, my lord.
Paper book 1.
Pardon.
Paper book 1.
Paper book 1.
We have
running page 724, please.
Page, it starts with 450.
Item number 4A, 4AB schedule I, 4A, 4B. Oh,
This material paper book number 1. Huh? This is 120.
Change schedule 4A. इसमें देखो है कहाँ है वो? Item number?
There's no 458.
Item number 29 है. नहीं दिया है.
My fault.
See,
But that's the schedule 4, Melody, it starts 456.
what this is?
This is a copy of the preliminary decree. This is the copy of the preliminary decree.
Yes, judgment, Melody. Okay. Judgment, Melody, and 458, Melody. This item 29 of schedule 4 is not.
Page 724.
Yes, 724. Melody, internal page 458, Melody, I made a highlighter mark, Melody. Item 29 of Janistan was missing in this.
Mister, have you got it?
Lord, I will have to verify because my learned friend wants to see from the schedules. I applied for the certified copies of the schedules. The office has not furnished me so far certified copies because that is not given. Schedule is not given.
It must have been supplied to you.
What I request you, Lordship.
Yes, supplied it.
No, that is not certified copy. I wanted schedule file when you along with the plate. May I request you, Lordship, to take issue number 10, judgment copy.
No, Mister, he is trying to point out from the schedule that this is not the property of CS, not subject matter of CS 14. You have been supplied with a copy of this paper book for us. Please see. He is referring to some page. Please see 724, 726.
726, item number 29.
Is missing, Melody.
That is missing. It only says, it only says areas of 2 acres.
That's all. That's not of Janistanpur, Melody.
So your submission is the Janistanpur village property is not a part and parcel.
Exactly, Melody. My lords are right. That is all I'm trying to explain, Melody.
So see page 724, Mister.
That's why I'm saying issue number 10 covers that. Judgment itself shows that. But the other details I will not.
No, but have a look at it. What does it say? You don't have the paper book.
Jamistapur property was a part of the suit schedule property. Item number 29, schedule 4. And issue number 10. Issue number 10 is
judgment in the schedule. I'm not saying anything against that.
All right. Go to page 726.
Yeah, but
726.
To open bench. What to do? Say, this is not a property. So it will go before regular bench.
Oh no, why? I will point out.
If you are not prepared to listen live and this thing, what can be done, Mister? It can be most unfortunate thing. Not even we are requesting you to please see, come to page 724. Please see what is there. You are just like issue number 10. Fine. We will say that we have passed an order. It will go before regular bench. Any more properties? There was no mention of this particular village.
कौन बोले delete करेगा?
What is the judgment?
Because of the filing issue number 10.
It has to go before, then it will not come before this regular bench, you understand? See, if it is not, it comes to us only when it is part of CS 40. Learned counsel for the appellant We were asking
Along
you
with
to
the-
make submission, you did not make submission.
No, no,
10 minutes.
plaint, yes, sir. The plaint in the, along with the plaint, schedules were separately given. They were never received as a part of the plaint. I have got a certified copy of the plaint also. It was never given there. So that's why I applied for the schedule, certified
We
copy of
have
the
passed
plaint.
an order. We have passed an order to be regular bench.
क्या दिख रहा है?
Yes.
अच्छा ठीक है ठीक है ठीक है मैं वही बोल
Yes, sir.
Grievance in this, interpretation is, mallards, the inaction of the authorities. In taking action for removal of the encroachments on the mallards government land. Mallards, that they claim that it's a kandakam.
So you are not taking any action, right?
That is the complaint, mallards, in the.
Removal of encroachment order, where is it?
Mallards, I have the copy, mallards.
Removal of encroachment, you have taken action.
For some of the authorities, mallards, fact.
In this matter, my lord, senior counsel Raghuram is appearing, my lord.
He is appearing before us. You are not visible, madam. He is appearing before us, we can see him and hear him.
That should be taken up tomorrow, my lord.
Why? He is not saying tomorrow, he is ready. Why?
Let's may I say. I have passed on the order copy. Yes, I have passed on the order copy with respect
What
to the
order?
encroachments, mallards. Mallards, in the encroachment order copy, mallards, passed by this honorable court, I have passed to your
That is also covered, my lord. Item number 51 to 68 is covered, my lord. That's why I'm requesting.
Covered?
Item number.
What is it?
Plus in the similar matters, mallards, passed an order. Plus the grievance is that, mallards, inaction. Plus the impact counter.
Please see, Mr. This is the order which we have
Seen, my lord, my friend has given, it's not modification, I think that should be, only thing, my lord, this case, though in the style of a PIL, individual has filed it, I don't want to get into technicalities. Jurisdiction, this on court only we are not concerned. My lord, their contention is the particular land is designated as a kandakam in the local language.
You have seen the order. We have said that we have not expressed any opinion. You will be given an opportunity to establish your claim. Whatever filed documents, this say, it says that in case any order is passed, you shall be at liberty. It is clarified that.
I have seen it, I only want, if Lordship's permission, two additions to that.
So we may tell you this the pro forma order which my Chief Justice in Madhya Pradesh used to pass in case of a removal of encroachment, Justice Khanvilkar. And this order has been upheld by the Supreme Court also. I have been a part of this order. So this is very innocuous.
It's fair enough, my lord. I'm only saying that in the facts of this case, there is a contention that this particular land is designated as Abadi in the revenue record. So, what I would submit is, if it is Abadi, it will not amount to government land, therefore they will not be encroachers. That aspect also may be considered by the collector. Collector also has himself said it's Abadi.
No. So it is see the directions. Yes, please see. Give him a copy. Please see. Peculiar facts following directions. Please see page para 6.
Para 6, yes, my lord. District collector shall issue notice to petition as well as unofficial respond. Every person who may be so occupying district collector or furnished documents supported the claim.
Please very clear.
Very well.
Please very clear.
And mallards.
Right.
Including the Lord, in case it is found to be government land, we are entitled for regularization as per the government GOs.
Whatever. We have said in the next paragraph, this thing remedy available to you, that is also granted.
Only if your thoughts can add, my lord, including regularization, perhaps that would be.
No, that we don't know, as of now, we don't know whether it's a government land or.
Yes, it is not. It's our contention.
Then yes.
That's in
Very
fact,
well. I think that will be enough to protect our interests.
That's in fact one submission. Counter affidavits have been filed. Mallards, stating that there are encroachments and the authorities, mallards, have
All
initiated
right, so in this, mark the everybody's
only-
presence, madam.
one submission.
It is the usual order, right? You have given, we are passing the same order. in this.
It goes about same collector. If likely you can need the same boundary, you already take the stats. It not be.
Yeah, but this thing in a writ petition we cannot decide, right? So if you want to establish your title, what are you doing? You should have filed a civil suit seeking a declaration that you are the owner. In a writ petition, in a public interest litigation, you want adjudication of your title that it is, we can't do that. Fine, we cannot decide your title that respondent is the owner of the land.
No, our claims
In
will
a
be
pub-
considered, that's what you also say.
Yes.
So that will be sufficient.
This is, if you are aggrieved by his decision, take recourse to the remedy. What is the use of keeping this PIL pending here? Right?
Batch of matters tagged onto this mallets.
37. Which other?
They're all up to, I think, about 60 matters of this.
37 to?
I have given batch numbers.
Huh?
Today this I have given my numbers.
Huh?
Yes. 142 to 41 to
40 also. 38. What happens to 38? No.
item number 132.
This is the Then which, at least you should 41 to 50. Arre, 41 to 50. Madam, same order.
130.
For 1 minute. 41 to 50, then 53 and
168.
53 to 55. 1 minute. Then,
Item number 113.
huh? All right.
Item number 113.
113. Same. Removal of encroachment.
Then
Huh?
These are filed by the individuals against the proposed action of the respondents to remove the encroachments.
That can't be. That petition can. These are all. This is what removal of encroachment, right?
As the authorities initiated action against that mallets, they have come up. Item 37 is inaction.
Ah.
And all other mallets petitions are when the authorities mallets contemplated action against them. They have approached and
So now, I mean, in view of the order,
yes,
that's what we should say probably.
All can be disposed of.
So 37 is disposed of, right? You are
113, sir.
Huh?
113. Item
1-1. This liberty, right? Huh? 113.
That's 81 to 81 to 98.
81 to
98, madam.
54 to 116.
1 minute, madam. 81 to 98.
98.
81 to 98. Same order, madam.
Plus 60.
Like with the liberty. 1 minute.
116, Lord.
What?
I think both of them appear for one party.
Huh?
Both of them appearing for one party. Ms. Padma. I think you can tell Ms. Padma's numbers.
Well, it's item 65 to
65 to
70. 76.
73, 74 you have already told. So 65 to madam, 71.
My cases are 54 to 116, Lord.
All cases.
Cases.
Yes, same, madam.
They include all these intermediate thing, my lord. All of them belong to her.
54 to 116.
Yes, Lord.
Madam, we hope that you are only correct and we don't face any review petitions, right? Huh? You are the counsel in all the cases?
Yes, Lord.
Huh?
Most of the cases.
Most of the cases.
No, but she is getting others cases also disposed of.
Other cases, my lend friend is here.
My friends can write down, my lord, and
that's
of your lordship has been troubled with this.
54 to 116, madam. All right.
Yes, Lord. Yes, Lord.
Let's the other batch minutes, lordships. Watch the notice.
With the, because
it is open to the authority to initiate.
initiate action. Question, it is open. One sentence.
Plan, then they will take.
Yes, sir.
Steps.
Correct. 54 to 116 and this.
So, some of the matter not listed, your Lordship, I'll provide this tomorrow.
Provide? Yes.
Obliged. Tomorrow.
38. Yes, Mr.
May I please, your Lordship? I am for the petitioner.
I am Dr. Lakshminatma on behalf of the respondent bank, Madam. I am ready, Madam.
Bank? What bank?
Union Bank of India, Madam. Sorry, Madam.
No, that's correct. But what like? What's the matter?
Let petitioner let him start, Madam.
Huh?
Let the petitioner start, Madam. Because if I start something.
Service matter.
Service matter.
It's a service
What
matter.
happened? He held against you, punished.
Is nothing but based, aggrieved by the impugned order. Petitioner approached to the Honorable High Court, filed the writ petition in the year 2009. And this is some orders were also there from that single bench, as well as the Supreme Court direction also.
What happened? You committed some misconduct. Departmental inquiry held against you. What is the punishment?
In the eye of the people, it is your Lordship, maybe like the misconduct you are mentioning, it is looked into means it is nothing but the bloated egos. Bloated egos and pointing out the person stating that you have.
That's correct. Bloated ego doesn't mean, or like, it doesn't give us an idea what punishment was imposed on.
Without giving the person what it is to be heard, simply that removed him from the service at the age of 50.
Removal of.
Remove Lordship.
1 minute. The case is very simple. You are an employee of the bank. A departmental inquiry was held against you. So therefore, penalty of removal from service has been imposed. That has been upheld in appeal. Those orders passed by the disciplinary and appellate authority you are challenging.
Yes, Lordship.
Simple, right?
As well as
there is no question of like, then we will come to the facts of the case later. We want to understand what is the case. This is it.
Yes.
Okay. Oh. It's not okay to say okay.
Yes, Lordship. Obliged.
We are not in informal conversation with each other.
In fact, this Lordship, this is having the cascading effect on all the other cases also, where I have to rush from some other court to be present here. But due to the arguments taken in a marathon way, senior counsels or learned counsels, this is getting dragged on from past 4 weeks.
No, we are hearing you. Instead of what happened 4 weeks, you argue.
It is, because, yes, Lordship, coming to the point of the page, the main writ petition, Lordship, that is the page 54 to 57.
Gross violation under article nationalized bank. Insubordination.
Lordship, here in this one, the synopsis of the complete writ petition is produced by, on the dated, this is 52 pages one document. Additional material which is filed on.
This is an argument, not facts. Because this page 12 is the appointed specialist officer law with a prerequisite qualification joined.
May I make one submission, my lord?
Not you had filed SLP.
Yes, Lord.
Dismissed.
No, it is the direction is stated to the Honorable High Courts to expedite the matter at the earliest. From the Supreme Court, Lordship,
This you have in the synopsis says 1/12/2008 order. SLP filed by the petitioner dismissed by Honorable Supreme Court.
Supreme Court stating that it is directing the Honorable High Court to expedite the matter.
No, what have you said, Mr.? Come to page 19 of your paper book. We are looking at that. Where is the order dated? Give the order in SLP. Is it on record?
Yes, Lordship. It is on record. Item number 7 of the Supreme Court. This is pertaining to the
No, SLP 27887 of 2008. Come to page 12, at least open page 12. What have you said?
Hello. Sir, ఏమైందండి?
Mute. Huh? Page 12, Mr. Where is synopsis? Sorry?
Just a second, Lordship. Yes.
Page 12. It will not be at the bottom. Page 12.
This is a writ petition in the bond. Writ petition is filed, bonded in the last that is the main writ petition.
No, this is what we don't know, Mr. This is says it is signed petitioner in person 1/12/2008 SLP number 2887 of 2008 filed by the petitioner dismissed by Honorable Supreme Court. Thereafter the date is mentioned 31/8/2009 and you have signed petitioner in person as a long signature.
Yes, petitioner in person. After that one, it is even handled by the advocates. But whereas
No. 1/12, please show us the order dated 1/12/2008 in SLP number 27887 of 2008. Page 92. 92. See,
Lordship,
you don't see, right? You are not ready with the case.
Right, Lordship, but here in this one, the Lordship, just give me this one. Lordship, just my humble submission. 52-page document which is submitted on 38/23. This is the 23rd June 23. 23rd June 23. As additional material which is given. This is a synopsis of the complete writ petition, including the additional affidavits and
Which is straight we get filed a writ petition. SLP dismissed as withdrawn.
Lordship.
Go ahead, Mr. Argue your case.
This is a 52-page, Lordship. That is the document which is additional material to be taken is 23rd June 23. 23rd June. This is filed with the notarized one. One main copy is there. I think additional copy also is provided to the Lordship also. So I have to be directing from the director from the single bench. That is the copy which is filed here, additional material. It is nothing but the synopsis or comprehension of the complete entire writ petition.
So what was the order passed by the Delhi High Court on 11/8/2008?
Delhi High Court also is nothing but is the same, Lordship, that is where this person, in fact, for the ONGC, he wanted to try, and ONGC,
No, we are simple, Mr. This come to page 92 of the paper. We are seeing your documents only. And you are behaving as if something we are.
It's not, I am creating.
So the page 92, see the order. First, you did not tell us that SLP, you had challenged the order of dismissal directly before Supreme Court. Then you withdrew that special leave petition. Second order is again SLP number 27887 2008. In that page 92, you have challenged the order passed by Delhi High Court. We are asking you, what is that order? 11/8/2008.
I read it out, Lordship. This is from the judgment and order dated 11/8/2008 in CC number 991 of
Hey,
2005.
don't read it out. It has been dismissed. We are asking you, what is the order 11/8/2008 passed by Delhi High Court? What read out?
So petition was called on for hearing on 1/12/2008, that is. This is Lordship. 11/8/2008. On 1/12/2008, this petition was called on. And here, upon hearing, the council paid the following. The special leave petition is dismissed. That is what he is saying.
Please see the order, record of proceedings. Please read page 92, record of proceedings. Yes.
He is reading that
Yes, the
only.
special leave petition is
We are not understanding that this, what is the
From the
order?
judgment and order dated 11/8/2008 in CCC, so and so of the High Court of Delhi. What is the question is, what was the order in this?
This is in page number 85, that is the High Court order. Page 85, Lord.
Order of promotion.
Shall I read out, Lord?
No, this not be, his dismissal has not been appealed. It was a claim for promotion. Yes, argue, Mr.
So impugned by the order, coming back to the page 52A, Lordship, in the main writ petition. Page 52A, the main prayer.
Hey, Mr. What are the facts, right?
Facts is nothing but the person.
Nothing. We will also write, sir, nothing.
Contents, Lordship, it is not coming into the impugned order, stating that he had done so and so. Only simple thing is that he is not obeying and he is on the insubordination. What is that insubordination is not described properly. The person never asked his seniors to either.
You are not 13%, right? You are not 13%.
I am for the petitioner.
Petition counsel, right?
Legal aid, counsel for petition, Lordship.
Huh?
Yes, Lordship.
Legal aid.
Legal aid matter, this is the legal aid matter, Lordship.
You are a counsel for legal services authority.
Yes, Lordship.
And don't know how to argue case.
This is
how many years of practice, Mr. Interesting.
Yes.
5 years.
Yes, Lordship.
So you how do you argue a case? Like we are asking to, we'll try to learn something from you. Do you argue a case?
First, if mentioning the brief facts of the case, then proceeding with the contents of the.
And submissions, right? Making submission on what grounds on which you are challenging the impugned order.
Yes, Lord.
And substantiating it by case law.
Case law.
So what have you done? Like so far, we are asking you to argue. You are saying facts are nothing.
No, in the sense, Lordship, that insubordination which is made out is.
No, Mr. You are not fit to argue the case. We are sorry to say. No. You are not fit to argue. You don't understand. And don't know how you have been empaneled as counsel.
It is to be
facts. You will not tell us the facts.
I'll come to the page 52A, Lordship. This is the main prayer. The contention is here, the contentions.
Now, who has assigned the case to you? Legal Services Authority.
Yes, Lord.
All right. Go ahead.
What shall I come to the main page number 52A, Lordship, the main prayer? In this one, it is mentioned, it is therefore that this honorable court may be pleased to pass and issue any order, direction, with including the writ of censure, a writ to quash and set aside the impugned order of dismissal. Illegally and unconstitutionally passed by the reviewing and final authority under the respondent bank's relevant service regulations.
Well, you could have given a brief synopsis. You are referring to the synopsis given by the party in person.
No, he is reading.
It is not party in person, it is additional material which is submitted by the petitioner himself. The petition is now based in Delhi.
Wherever he may be based in London also, but that doesn't make any difference, right?
That is not the issue here, Lordship. Here this
we know what is the issue, mister. This is too much. We are asking you, you don't know the facts.
Coming to
you don't know the facts. You are not told us what is the case against him. Who was he? You don't know anything. I mean, we are surprised that 5 years experience.
My apologies, Lordship. I am coming to the page 50. That's the 50.
You are reading the prayer clause.
It is not prayer I am reading, Lordship. This is a 52-page document, additional material, which is submitted on 30th June. In that document, it is a synopsis of the complete entire writ petition is there. If your Lordships allow me to read, then probably I can go through that one.
No, so argument is reading like synopsis prepared by the petitioner.
Not right? Petitioner. In that,
all right, sit down. Better sit down. You are incapable of comprehension according to us. Yes, mister. What is the case of? Yes, mister. You tell us.
Regulation 3.1, my lord, which he has not filed. He came up he has challenged regulation 3.1 of the bank regulations. Came up before the learned single judge. I have pointed out if he wants to challenge that, if he wants to continue with the writ petition, it has to go before a division bench. Otherwise, he has got a choice to delete this portion. So far, he has not argued why regulation 3.1 is bad in law.
He is not arguing anything. We are asking him, you have to tell what are the facts. He is unable to understand. We don't know. He has been assigned case by the Legal Services Authority. What's your name, Mr. Counsel?
N. Naveen Raj. N. Naveen Raj.
N. Naveen Rao.
Raj.
Right. N. Naveen Raj. Yes. So you tell us the facts. What is the petitioner's case? Then we will hear you after you conclude.
Very well, madam.
According to him, facts are nothing. Nothing. Everything is nothing. Yes. You go ahead.
Let him
1 minute. Don't interrupt, Mr. Too much of intelligence. This is not a. If the bench can withdraw the case from you also. But this is not a matter of right? If it has been assigned to you, it can be withdrawn to you. Behave yourself. You are here in the capacity of an officer of the court. And you don't know how to argue the case.
I am not violating Lordship, that is. The thing is that let the respondent give the facts itself, because it is the impugned order from the respondent side.
No. Impugned order means you will not tell the facts. You are unable to understand. You don't know how to argue the case. That's why we are asking him. That doesn't mean that he will give facts. Mr. Advocate General, see, since the impugned order is passed by the respondent, let them give the facts. This is the submission. So every order which you pass, you will have to argue the facts also for them. He is just standing up. Unfortunate.
Lordship, I am not
unfortunate. Yes. He is incapable of comprehension, Mr. We are sorry to say that. Yes, Mr. If you also don't know, then prepare the case and come tomorrow. Mr. Counsel for Bank, you give a synopsis what happened. Factual narration. And it's an order of dismissal after departmental inquiry.
Yes, madam. It is, madam.
When you prepare, give us the synopsis, date-wise list and your submissions 1, 2, 3, 4.
Yes,
Stated by case law. Nothing. He is incapable to argue. He will not say. He is saying nothing in the case. No facts. He is saying. We will record this that he is saying no facts.
Lot of facts. It is the file has bloated in size, Lordship. That is.